it is unfair because the last conduct of Katz is October 2012. He comes to be employed by us in 2013. And then they say you are drawing an inference based on the absence of evidence. Nothing could be further from the. Why we say the correct inference must be that Katz probably continued when he joined ANZ, or at If they say you've got the wrong guy, who is the right guy? Then, when you look at Brownrigg's affidavit, particularly at page 1875, he denies the conversation with Taylor was collusive. But here is an important factor. Taylor, and that's the most important thing in a Qatar, Taylor never submits an affidavit. Taylor never submits an affidavit. What happens to Taylor? Sintin, I wrote an email to Taylor asking him certain allegations. Taylor never sent an email in response. Never sent an email. Instead, according to Sintin, Taylor called him. And what we then have is a version of Sintin of those conversations. They have access to Taylor. Why are they not giving us Taylor's affidavit? So you have a one-sided version with no corroboration. Catalyst. It would be accept that without more. Brownrigg does not deny the knowledge and the use of CAC, which is a specialist but comprises only of lawyers but no economists. So that deference to expertise has been recognized by this court in Mediclinic, that when it comes to evaluation of facts, the Competition Appeal Court will only interfere where basically they were smoking their socks. Then you have a third category, which is discretionary decisions. In that third category, you will fit there a decision as to joinder. Necessity convenience. It's pure postponements or about condonation. You will then ask yourself whether or not the CAC has satisfied the standard rules for interference with discretionary decisions. Now, this is the problem we have here, is that basically what the CAC thought, it thought that it was the tribunal. It could redo the exercise entirely without any regard to what the tribunal said. Let's just do it the way we want. And that is very, very clear when it came to the joinder decision, because they never conducted an evaluation of the tribunal's reasoning to see whether it fits those patterns of appellate interference with discretionary decisions. So you've got two areas of constraint. One is factual evaluation, second is discretionary decision. And you've got one area of unrestrained interference, which is legal assessment.
Where you were at item that interests of justice have to be the determining factor. But what I'm asking is, what factors would we have to take in this matter to conclude that it is in the interest of justice to interfere?
Yes. Now, it's only if I am right in my primary submission that the CAC was wrong. If you say the CAC was right, fine, then there's no debate. But if they were wrong in CAC 2020, that is a factor that you are correcting a wrong decision. But it is also a factor that you are correcting a wrong decision in relation to jurisdiction. The second thing you will take into account is the stage at which the proceedings are at. This is right at the commencement of the proceedings. Then you will take into account prejudice. There is no prejudice in this case, and you know, I've heard a lot of things in this case. Everyone has a different rendition of what we said. Then they say, we've also distorted what we said. End up getting so confused. So on this point about lack of prejudice. You know, Justice Chief, in our pleading, I showed the court we relied on section 3.1. We also tried to comply because we thought we must comply. Otherwise, you know, we are an organ of state. But we also relied on section 3.1 independently from the connecting factors test. Before the CAC, we ran the argument that section 3.1 is decoupled from the common law. We know the consequences because the transcript is here. In this court, we ran the argument again. In 2020, we had run the argument. There is no one who can be prejudiced about this argument being raised here. No one. So we would say that those three factors would play an appreciable role in your assessment of where the interests of justice lie.
Thank you, Mr. Ngcukaitobi. Thank you, TCJ.
Mr. Ngcukaitobi, my question relates to res judicata, which you have touched on. In relation to the third respondent, do you accept that they may be prejudiced if we reopen the interpretation of section 3.1 in this court, since they did not oppose the application on the basis of that point being raised, the res judicata initially?
Justice Saron, no. Why would they be prejudiced? Because you are correcting the law. How can anybody be prejudiced with the correction of the law? And all of the arguments that had to be made have been made. This is one case. It's not separate cases. They want to raise their own case. But that just doesn't make sense, because why would they want to raise their own argument in addition to what others have said? What's the unique thing they were going to say? So no, I'm afraid no, I don't accept it.
Would those respondents who were joined later, the additional banks, would their position be different in relation to the previous respondents in respect of the res judicata point?
And no, they can't be. Remember that we added Incola and Standard Americas. Yes, Standard Americas and Incola. Standard Americas is here, the rest are Incola. They are irrelevant to the debate anyway.
So you say they won't be affected,
Yes.
whether they were joined later or previously by the res judicata point issue?
No, it's irrelevant to the Incola. And also irrelevant, I would say, to the two categories of foreigners with presence in South Africa, because there is another basis to exercise jurisdiction. It's only relevant to the pure peregrine, but the pure peregrine have run all of their arguments here.
I suppose whatever decision, if the court reaches a decision on the res judicata, it has to apply to all the in respect of all the respondents, whether they were joined before or later. And it shouldn't, if the court finds in favor of the respondents or some of the respondents' res judicata point, all the respondents should get the benefit of that.
Oh, no, I accept that, yes, entirely.
Yes. Thank you, Ms. Ngcukaitobi.
Yes. Yes. I'm told by my learned colleague that the point was raised in the application for leave to appeal to this court, so everyone had noticed. We noticed as well that, Justice Terod, there's actually quite a lot of parties that never took res judicata. They took preemption. Once they saw that the train was moving on the res judicata, they joined in. But anyway, I'm not going to complain. so.
Mr. Ngcukaitobi, first on the question of initiation, you say that the Competition Appeal Court only knocked out the case against the 24th to 28th respondents on the basis that the first judgment didn't allow further joinder, and therefore initiation is not before us.
Yes.
But if we take Standard Americas as an example, the actual order in CAC 2 was simply that its dismissal application is upheld, or its appeal is upheld, and its dismissal application is granted. The principle on appeal is that the successful party below, here the respondent in the appeal, Standard Americas, can defend the court below's order on any basis that could properly be raised. So that if there were 2 or 3 grounds on which it could have succeeded in the CAC, and the CAC only decided 1 ground, if that ground is wrong, Standard Americas can still say, but that order was still justified because we should have succeeded on the initiation point, which the CAC didn't consider. Isn't that the correct procedural approach?
No, that's correct, but it doesn't apply here. Because I actually considered the question yesterday before raising this argument. The reason it doesn't apply is twofold. The first is that here we are not without, we are clear about what the basis for the order was. The basis for the order is set out under findings, paragraph 184. That's number one. The second thing is that an order as to initiation would have invalidated the referral. So they would have said the commission had no jurisdiction to issue the referral because it was barred from doing so because of the absence of the jurisdictional fact. That order was not made. So we are not in a stage where your referral has been set aside, but we don't know the basis on which it has been set aside, and therefore you can defend it on any basis. The stage at which we are is it's the order of the tribunal on joinder that has been set aside. And it's been set aside on one basis, which is the absence of the incorrect interpretation of the 2020 order.
As a matter of form, that doesn't seem to be right because, and this is perhaps an illogicality in the CAC 2 judgment, that, and you'll say the only one, they didn't actually say that the the joinder application for Standard Americas is dismissed, which might have been the logical conclusion of its reasoning. They actually said its dismissal application was dismissed. Was upheld.
Was granted, yes.
Yes. So it didn't. The CAC didn't actually make an order on the joinder application. It made an order on the dismissal application. And what we have before us is whether the CAC was right to have held that the complaint against SAI, its objection to being a party to these proceedings, should be upheld. And I still don't see why it makes a difference. If the CAC in this case had said, reasoned, this is the meaning of the first judgment, it doesn't permit further joinder. If it had then added, for this reason, we don't need to consider the initiation argument. I'm sorry, perhaps you feel you can't say anything more on it, but I still don't understand why they can't, before us, say that even if the CAC was wrong on its joinder reasoning, we are still entitled to support that order on the basis of our initiation reasoning.
No, I think that the difference, Justice Rogers, is really this. Upholding an initiation means setting aside the referral against Standard Americas. That's the only logical way of upholding the initiation point.
Well, I don't think Standard America says we must set aside an initiation. It says we can't be part of this case because there wasn't an initiation at all against us.
No, setting aside in relation to them. I think we're talking about the same thing.
No, well, it would be setting aside potentially the referral against them.
Yeah, sorry, the referral in relation to them, yes. Now, that's the order we would have needed to constitute the jurisdictional fact to debate on appeal, that the initiation has been upheld. And we don't have to speculate here because after everything he has said, he then has a different section called findings. And in that section that is called findings, he says, I'm going to set aside, if you look at paragraph 184, I'm going to set aside the because you were prohibited by my 2020 order. So the discussion in paragraph 145 is not followed by any consequential relief. And in fact, it's not even conclusory because he says, I'm skeptical about your argument, but he never actually reaches a conclusion on it. It's only 184, and then you read that together with the order. And you apply the standard ways of interpretation of the judgment.
It seems to me your approach, you don't like Stalingrad, and I think nobody likes Stalingrad. Certainly the court wouldn't like it. But this leaves now for another day,
Which,
a fight by Standard Americas on its initiation and joinder point, because you say that hasn't been decided yet. And we can't deal with it because it hasn't yet been decided. All we can do is say that the CAC was wrong in regard to the effect of CAC 1. But that means a point which may be right or may be wrong hasn't yet been decided. Standard Americas is entitled to an answer on it. If it can't get it here, it will have to get it in some future proceedings before the tribunal.
as well, I suppose you could take that into account in the assessment of what is just and equitable as part of your Section 172 power. And then say, as part of our 172 power, which is a very broad power, one of the factors we'll take into account in deciding to decide the initiation point is exactly the kind of consideration that you're putting to me. But as a matter of law, what you cannot do is to conflate that finding that was made into a finding on jurisdiction in relation to the referral, because the judgment makes that beyond any contestation. If we are in Section 172, which I understand is a possibility to say, look, judicial economy, interest of justice, we must decide everything, including those issues that have not been decided. Yes, then I accept that you have the power to do that. Has Section 172 been invoked here as a basis on which you can decide that? The answer is no. Do you have mero motu powers to invoke it? Yes. If you are at that level, we have made the submissions about the tacit nature of the initiation against all of the participants to this currency fixing.
Thank you. My other question relates to res judicata. You said in response to a question from one of my colleagues that, firstly, this court can say and can correct CAC 1 on the law.
Yes.
Secondly, it then must consider whether, nevertheless, by virtue of res judicata, it remains binding between the parties in this litigation. It seems to me that in principle, not specifically in this case, but as a general matter of law, that puts it the wrong way round. The first question should be, is this point res judicata? If it is not, we can address the point of law. If it is res judicata, the whole point of res judicata is to take it off the table, to mean we shouldn't decide it. We can't decide it in this case. Now, I accept, of course, that this court can, when a judgment of the Competition Appeal Court is quoted to us as a precedent in relation to a matter that is properly before us, we can overrule any CAC judgment and say it was wrong. But it first has to be germane to an issue it is proper for us to decide. And to decide whether your Section 3(1) argument is right or wrong, is properly before us, we must first decide whether it is res judicata. At most, if we found it was res judicata and that there weren't grounds for departing from res judicata, we might say we leave open the question whether CAC 1 was right in this respect. But it seems to me it would be improper for a court that has found an issue to be res judicata to nevertheless say that that point was wrong or right. It would be, apart from anything else, it would be an obiter dictum, because it wouldn't be necessary for the decision in this case.
I think, Justice Rogers, we are debating the form in which the judgment should take. I am submitting that what is appropriate is that you must first decide whether 2020 CAC was correctly decided. And that is a separate issue from whether or not the doctrine of res judicata applies.
For what purpose for resolving what issue that is properly before us, must we decide whether CAC 1 was right or wrong?
Well,
what is the relevant issue?
Well, there is only one issue on that score, is Section 3(1), which you've identified.
Yes. So in order to say that we must decide whether CAC 1 was right or wrong, we have to find that the proper interpretation of Section 3(1) is properly before us.
Yes, correct.
We can only answer that question by first determining whether that issue is already res judicata.
No, I see your point. No, we don't accept that, because that's putting the cart before the horse, because you cannot use the doctrine of res judicata to interpret. You use the doctrine to decide whether or not I am bound, but not to decide correctness. Correctness is a separate inquiry.
I think in due course we might need to decide whether we prefer your horse in mine.
or yours. No, I think that's the other way around, but I see the argument that the way you are framing it is, let's start with res judicata and then go to correctness. Yes. My framing is start with correctness and then goes to res judicata.
On the question of departing from res judicata, you correctly mentioned that prejudice would be one factor.
Yes.
Not the only one, and not necessarily decisive. Now, I recall that some of the respondents have raised, but in any event it's inherent in the case, that following CAC 1, there was 3.5 years of litigation based on the footing that CAC 1 had laid down the ground rules for the future conduct of this case. Inter alia, on the strength of that, the Commission filed a superseding referral affidavit. That affidavit had to be examined by all of the respondents. They then filed, and probably 14, 15, 16 dismissal applications and exceptions. There are joinder applications. All of that, your client filed answering papers, there were replies. The matter was then argued, I can't recall over how many days in the tribunal, probably 3 or 4. It was argued over 4 days, if I recall correctly, in the Competition Appeal Court. All of this happened on the basis that the parties were testing whether what you had done in your superseding referral affidavit complied with CAC 1, including qualified effects and adequate connecting factors. All of that is wasted effort and wasted costs. Wasted time, wasted effort, wasted costs, if we can now throw CAC 1 out and say it isn't binding between these parties. Isn't that relevant prejudice?
No, not in this case, because they would have had to defend themselves anyway. And the fact that one of the grounds on which they would have had to defend themselves is the issue of jurisdiction. They always had to raise jurisdiction because they always disputed that there were adequate connecting factors. There is no extra cost that comes from a different slant to Section 3.1.
But if the argument was that everything turned only on some effect and that the involvement of the RAND constituted that effect, if that point had been appealed and had been upheld by us, we had accepted your 3.1 argument in an appeal against CAC 1, none of the parties would have taken or could have taken any of the objections which occupied a lot of the time against absence of adequate connecting factors, absence of proper pleading of qualified effects. There would still have been objections about whether there were sufficient facts to show that a particular bank had joined the conspiracy or not. But a lot of this case would have been rendered redundant by a timely appeal against CAC 1.
I'm skeptical, Justice Rogers, and I say this in all seriousness. I'm skeptical about that assumption because even a Section 3.1 pure argument was still met with an objection based on effect throughout in this trial, this particular case that we're dealing with.
In round 2? It was
round 2, yes.
Yes, but that was on the basis of were there foreseeable, direct and substantial effects.
Yes.
In other words, qualified effects.
Yes.
Your argument is that that isn't the test. If we had upheld in an appeal against CAC 1 your argument that any effect whatsoever suffices, then that line of attack would not have been open to any of the banks.
No, I mean, we still accept effects, but obviously not qualified effects. But because the section itself says effects. Yes. So, yes, that is possibly true that some of the banks could have reconsidered their position. But I am skeptical, having lived this case for 7 years, that that assumption is correct. I think that we would have still been met with jurisdictional objections. I still think, even if you directed them to go back and plead over, I think there is still 1 or 2 objections coming. So I'm not as confident as you are, I'm afraid to say.
No, I was raising it as to whether it's not prejudice. I've heard your answer. Thank you.
Okay, thank you, Justice Roger.
I think we've reached that point. We've gone past it, actually. But Justice Matopa has a question. Justice Matopa?
Yes, just.
This issue about jurisdiction troubles me a lot. For the simple reason that if it is against, it's decided against you, what are the possible scenarios available to the competition commission? I'm taking a more practical view, a holistic view about what this case is all about, and asking myself, you did not take the point at CAC 1. This is the debate that I had with Mr. Loxon on the implications, the nature and effect and implications of this plea of res judicata.
We looked in CAC 1.
Yeah, I must say it troubles me.
Yes.
1 and 2, whether you should have appealed or did not appeal, and because you did not appeal, you are precluded, you cannot raise it before us now. And now you're saying it's a matter of law, it's a point of law, you are competent to raise it, but you are met with a plea that says you can't. If you had to raise it, the option was to raise it back then, you can't raise it now.
Yes.
And you're saying to meet with that objection, you would say we should relax it on the basis of the interest of justice. Did I understand you correctly there?
Yes, I have had to embrace that alternative argument, despite myself, because my primary argument was that it's irrelevant, because I'm raising an interpretation of Section 3.1 of the Act. And that's a question of the correctness of the 2020 order, which you have the authority to decide as per Mutsila. That's the primary argument I had raised. And you are not bound by what they decided. You must decide what the law is. Then...
Oh, sorry, I was trying to look at Mutsila, the relevant paragraph. I know I was on the panel, yeah, but I've forgotten what it says. Can you just quote the paragraph?
Let's ask Justice Teron.
No.
Sorry, Judge, I don't actually
I have the judgment with me here.
So I don't have it. I'm going to try to make sure we get it. What is the paragraph?
Because I just want to know what we said there in Mutsila, which you are embracing.
Yes, I'm told Justice Matopo is 100,
I'm at 100.
101, 102, and 103. So the actual finding is 103.
So embracing Mutsila, you would argue that in 103, we should borrow from what we said in 103 to apply pari passu in this case as well.
Yes, yes. On the correctness issue, not on the res judicata issue, yes.
I'm now worried about precedent, stare decisis.
Well, you have it, Mutsila.
If this is what we said in Mutsila, and we are urged to say something different in this case, and we may take the flag of inconsistencies with our judgments, unless if your reading of Mutsila, I still have to apply my mind. Unless if your reading of Mutsila, it's not opposite. It can be said to be distinguishable.
Yes, I mean, legal reasoning is an elastic thing. But you could say that this case, we have to decide res judicata first, and therefore we don't engage Mutsila at all. And that is a point of distinction. But again, in this elasticity of legal reasoning, you could also say that the correctness as to jurisdiction is such a fundamental issue, which is what has been cited here from cases like Mays Board. And you will not allow a jurisdictional finding to stand, because that will perpetuate a legal wrong inconsistent with the statute, and you take it as a matter of principle and decide, and Mozilla would be good authority for that.
I need to think about this. But as you know, as you may have been aware over the days, it has been a source of concern for me.
Yes. No, I appreciate.
I don't have the answer yet. Yes. I have listened to the forceful argument by Mr. Loxton on the point, and Mr. Cockrell as well, and your equally persuasive argument on this.
Well, I hope I'm the only one who's persuasive. Thank you, Justice Muto.
We will, is there a question? Okay.
Toby, just one question from my side. You've urged us in embracing the idea that there was a single overarching conspiracy to conclude that the only reasonable inference to be drawn is that all of the respondents were part of that conspiracy.
Yes.
You don't suggest that there were bilateral agreements, but if they were part of a conspiracy. Or,
Yes.
And as I understand your argument, your suggestion is that if two traders were in a chat and the chat evidenced conduct of fixing,
Yes.
then the fact that the other trader was in other chats
Yes.
would be sufficient to draw the inference that this trader who was in a single chat was part of a conspiracy, correct?
Indeed, indeed. Thank you.
Now, just arising from that, when I look at the referral affidavit, and the referral affidavit deals with the direct, immediate, and substantial effect test, even though you don't primarily rely on that test, you rely on the effects test, correct?
Yes. Yes.
Now, under that section, there are two sort of subheadings, and the one deals with foreseeability, and the other deals with the cumulative effect.
Yes.
The tenor in both those sections speaks of both the period of time
Yes.
and persistence.
Yes.
So the suggestion is that time and persistence are in fact relevant considerations in the conclusion
Yes.
around foreseeability, around cumulative effects, and fits into that mode.
Yes.
When one then posits that against single conduct, for example, could it be said, well, there are two inferences that could be drawn. The one, that even the single conduct provided with somebody who's involved in other type of conduct may lend itself to the reasonable inference that you're part of the SOC.
Yes.
But another inference that could be equally reasonable could be that's an isolated incident. And the fact that you're associated with Mr. Iyer, for example, and if Iyer is involved in other chats, that may not be a reasonable inference under those circumstances, especially in the light of the assertion by the Commission that time and persistence would be a factor. How does one deal with time and persistence in the context of lending itself to a reasonable inference when it might militate against that?
Justice Kolopin, firstly, I accept that time and persistence are relevant. They are actually very strongly relevant. Yes. And I accept that instances of singular participation would also be relevant, but not decisive. And then if you are in that mold, you then have to look at other surrounding factors. And those surrounding factors then could be the nature of the collusion, the currency pair that is engaged, the counterparty to it. And then, bearing in mind what is said, and I'm very grateful that you've taken us to the effects section, because it's actually a strong section on knowledge. Bearing in mind what they knew, if you look at 275, the last sentence there about what they knew. The traders were aware of this when they engaged in the collusive conduct and posted quotes, or in some cases withheld quotes, on international trading platforms with the aim of manipulating the ZAR. So That's what they know. They know what the effect of what they're doing, even though they are purporting to be acting bilaterally. Then in 276,
Just interrupt you on that. Would you disagree that when you say the traders would have knew that that's a conclusion?
no, it's supported later if you look at 466, because I've also taken that note into account. Why did they know 278? The traders could see in real time the effect of their manipulation of the currency exchange and the lasting impact on the bid-ask spread. So they could see, as they were doing it, what was going on to the currency.
Sure.
It's not a conclusion without fact. It's a conclusion plus fact.
But is it not equally be contendable that even in a bilateral relationship they could see? And that doesn't necessarily lend itself to reasonable inference that they were part of a conspiracy. What I'm saying, it could cut either way.
No, the problem with that is that it can't cut either way if you look at what they could see is the impact. Because if you look at what they could see is the impact, there's no reasonable way that a pure bilateral once-off chart could have these catastrophic impacts that are described in 275 to 279. So what they could see, which was going on in the global markets on the trading of the rand, is only consistent with knowledge of the conspiracy as a whole, completely inconsistent with knowledge only of that bilateral conversation. And the last thing on this point is just to refer the court to the findings of the tribunal at 132, paragraphs 132, I think these are in volume 2. Volume 2, volume 3. But in the judgment of the tribunal is 133, 134, 135. And then it goes on to 143. Because they examined this in detail, this question of what could be inferred from what was happening. And then it said, when you look at the entire picture, it is fanciful to think that these traders only knew that once-off chart. The actual realistic way of understanding this is as an integrated system of collusion. And interestingly, these findings are actually just not dealt with at all in the CAC finding.
Okay, thank you, Mr. Dubaitobi. Thank you very much.
Thank you, Mr. Chief Justice.
I don't think there are any further questions, so we're going to take our 15-minute tea break. And when we come back, we're going to deal with the cross appeal. See, Mr. Cochran is ready. Photo, gents.
issue by Justice Rogers. The note was provided to us yesterday, I believe it was. We haven't had a chance to respond to it. And so the purpose of my request is simply to ask whether you would give all of the banks leave to file a response to the list of legal questions. I've got no instructions about how long it would take, but it would be a few days, I would imagine. That's just my request, and I'm just the messenger, Deputy Chief Justice.
Well, I'm surprised by the lateness of that request, because when I asked yesterday whether it's been shared, I had nothing, so I thought there was no issue. But certainly,
Thank you.
but only not to re-argue anything. So we'll grant that.
Thank you very much, Deputy Justice. There will be no re-arguing. It's just an attempt to respond to the list of legal questions that the Commission prepared.
List of legal errors, I think. List of what's English is not my first language.
Thank you very much. Thank you very much, Deputy Chief Justice.
As long as that's clear, it's not an opportunity to re-argue anything.
Yes.
It's just to respond to that note.
Deputy Chief Justice, I can only respond on behalf of my client, and my client won't re-argue the matter.
You, the messenger, you'll tell them.
I'm the messenger. I'm sure my learned friends won't abuse the occasion either.
Thank you.
Thank you, Deputy Chief Justice. As you know, I act for two HBSC entities. The one is HBUS and the one is HBU. This address is an argument on behalf of HBU. HBU is the applicant in the application for leave to cross-appeal. And you'll know that HBU is a local peregrinus because he does have a presence in South Africa. And the essence of HBU's cross-appeal is that although the Commission has jurisdiction over it, the Commission has the wrong guy, to use that phrase. What we know is that the Commission cited HBU as the employer of Mr. Hutton, when in fact it was a different entity within the HSBC group that employed Mr. Hutton. And that's the argument I'm going to develop today in my 15 minutes. I want to spend most of my time in arguing for why the Commission has the wrong guy. And that will take up most of my 15 minutes. And then if time permits, I'm going to make very brief submissions regarding why the correct procedure was used by HBU in order to take the point. And then finally, if time permits, I'm going to deal very quickly with the requirements for obtaining leave to appeal, or in this case, leave to cross-appeal. So those are the three issues I intend to address, and let me then start with the major issue, which is that the Commission has the wrong guy. Deputy Chief Justice, in order to come home, what the Commission has to persuade this court is that either the conduct of Mr. Hatton, or the conduct of Mr. Merkovich, or the conduct of unnamed traders could be attributed to HBU. The only three possibilities in that regard. It's the conduct of Hatton, conduct of Merkovich, or the conduct of unidentified traders. I'm going to take that in reverse order, if I may, and let me start with the unnamed traders. Now, the Commission's averment is so vague in this regard. All we are told in paragraph 66 of the founding affidavit is that the conspiracy was implemented by various people whose details are unknown to the Commission. And our respectful submission is that averment doesn't get off the ground. It doesn't even suffice at any level of pleading. The Commission says various people implemented the conspiracy, doesn't know who they are. So to try and suggest that HBU can be attributed with liability for the conspiracy on the basis of that averment, in our respectful submission, is simply a non-starter. That brings us then to Mr. Merkovich. And Deputy Chief Justice, the only way I can deal with this is to ask you and the members of the court, please, if you'll go to paragraph 97 of the founding affidavit. It's paragraph 97. It's on page 411. And in paragraph 97, and again in paragraph 217, there you'll see the only allegations which seek to attribute liability to Mr. Merkovich. And the allegations are so vague and perfunctory that with respect, they simply don't bear any serious consideration. The one allegation is that Hatton made reference to his conversations with Milo. We know that Milo, or Mijo, is Mr. Merkovich. And the other allegation is that Ayer said that Milo had taken 15. Now, whatever those averments mean, they are far too vague to suggest that any liability can be attributed to H. Bew for the conduct of Mr. Merkovich. So we respectfully submit that Mr. Merkovich is also a non-starter when it comes to ascribing liability to HBU for the SOC. And that brings us then to Mr. Hatton. Now, we accept that Mr. Hatton is implicated in a number of chats. However, the problem in our respectful submission for the Commission is that there's no evidence to show that Mr. Hatton's involvement was in his capacity as an agent for HBU, that's the European entity, rather than as an agent for HBUS, which is the American entity. And for me to develop that argument, let me start by asking you to go to the inference that was drawn by the CAC. This is in CAC 2. You'll find it in paragraph 135. And I'm just going to read it to you to save time. What the finding of the CAC was in paragraph 135 is that while the 19th respondent, that's HBUS, admits that Hatton was its employee, the allegations of participation in trading contained in the referral affidavits entitles the drawing of an inference that the 14th respondent, that's HBU, has been correctly connected to the SOC. Now, with respect, that finding is just devoid of any logic. What the CAC says is, because HBUS was involved in the conspiracy, it justifies an inference that HBU was also involved in the conspiracy. And in our respectful submission, there's simply no logical basis for drawing that inference. And the position becomes particularly marked when one now compares what the CAC said about the other banks to what the CAC said about HBU when it came to drawing the inference. And can I ask you, please, if you can go to paragraph 88 of CAC 2. And let me read you, again, just to save time, let me read you the finding in paragraph 90. The finding of the CAC was the Commission also alleges that Cook and Shepard were employed by and or representing Merrill Lynch, alternatively Bank of America. They were authorized by Merrill Lynch, alternatively Bank of America, to trade in the US dollar ZAR currency pair on its behalf. This is devoid of the kind of specificity which was required by the 2020 order or by a referral that could pass legal muster. So what the CAC says is, those averments are too lacking in any specificity for liability to be attributed to the relevant banks. But with respect, those are exactly the same averments that were made in relation to HBU. So the oddity, and I say this with respect, the oddity of the CAC's position is, they say, in the case of the other banks, there's no basis for drawing an inference that liability should be ascribed to HBU. But when it comes to HBU, on the basis of exactly the same averments, they say there is a basis for drawing the inference that liability should be ascribed to HBU. Now, I've elaborated on that submission, but exactly the same finding is made in two other paragraphs of the CAC judgment in CAC 2. The one is in paragraph 125, and the third is in paragraph 66. I don't have the time to take you to those paragraphs. I would ask you to read them in due course. And when you read them, the question to ask yourself is, how did the CAC draw the inference against HBU, but not against those three banks when the factual allegations were exactly the same against HBU and against the other banks? If I go on then to the factual position regarding Mr. Hatton, let me try and cut through some of the clutter, Deputy Chief Justice. There are two issues which emerge on the pleadings. The first is whether HBU employed Mr. Hatton. The second is whether HBU authorized Mr. Hatton to trade on its behalf. Now, the first issue we understand to be a non-event, because my learned friend, as I understood it, very fairly made the concession yesterday that it's not the Commission's case that Hatton was employed by HBU. And if you need any support for that, if you go to paragraph 65.7.1 of the founding affidavit, you'll see that is not the Commission's pleaded case. What the Commission's pleaded case is the one we find in paragraph 65.7.1. And there we find the allegation that Hatton was authorized by HBU to trade in the US ZAR currency pair on its behalf. So that's the only hook that the Commission can use to try and get its tentacles into HBU. The averment that Mr. Hatton was authorized by HBU to trade in the US dollar ZAR currency pair on its behalf. And with respect, I'm going to give you a number of reasons why that bare averment doesn't suffice for the Commission to make out its case. I need to refer you to some law in this regard. The first is the judgment of the CAC in Graylio. It is referred to in our heads of argument, the judgment of the Competition Appeal Court. And Graylio, paragraph 42, makes it clear that without proof of authority, the Commission's case doesn't get off the ground. And then the other authority I want to refer you to is one that isn't referred to in our heads of argument, but I did tell my learned friend last night that we intended to refer the court to it. It's ESCOM versus Soweto City Council, 1992, Volume 4, South African Law Report 703, the judgment of the Witwatersrand Local Division, and the relevant passage is at 706C. Now, in the light of those two authorities, I want to make 4 submissions to you in the time available to me. The first is, the Commission has put up no evidence whatsoever in support of the averment that HBU authorized Hatton to trade on its behalf. There's no evidence in that regard, and the averment clearly falls outside the knowledge of the deponent. How would the deponent have any knowledge about the authority of Hatton? Well, he or she doesn't explain it. And what we do know from the papers is that the Commission never investigated whether Mr. Hatton had authority to trade on behalf of HBU or not. So the allegation is a simple allegation. It's made very fleetingly and by someone who couldn't have any knowledge of that fact. That's the first submission. The second submission is the Commission's averments regarding authority of Mr. Hatton. They are simply cut and pastes of the similar averments which are made against all the other respondent banks. I'm going to give you a number of examples. I don't have time to take you to them. In the founding affidavit of the complaint referral, if you'd have regarded paragraph 65.2, 65.3, 65.4, 65.5, 65.6, and then the pattern carries on. The allegation is made that there was authority on behalf of the relevant traders, but there's simply no proof in that regard. The Commission's allegation is simply a cut and paste of the averment that they put up in the case of the other banks. The third submission I want to make is, in competition proceedings, it's not sufficient to plead legal conclusions as it would be in action proceedings. So in action proceedings, you can get away with drafting a very skeletal set of particulars of claim. But the whole point of Rule 15.2 of the Tribunal rules is to say that there's a burden, I don't mean that in a legal sense, but there's a burden on the Commission to substantiate the averments and to plead the material facts. So it was therefore incumbent on the Commission to tell us what is the factual basis for the averment that they rely on to say that Mr. Hatton had authority to bind HBU, and there's simply nothing there. The fourth submission I want to make is that the Commission is not an ordinary litigant. As you know, because you've heard from my learned friends about this, the Commission attracts certain duties which do not attach to ordinary litigants. And our respectful submission is it was quite inappropriate and improper for the Commission to make this unsubstantiated, bald averment regarding the authority of Mr. Hatton. And in doing so, they circumvented their constitutional obligations. Now, you heard my learned friends, Ms. Hofmeyr and my learned friend, Ms. Engelbrecht, on this. I'm not going to repeat their points, but we would simply support all of the submissions they make regarding these throwaway averments, which do not suggest that the Commission has investigated the matter. On the contrary, it suggests that the Commission has simply absolved itself of its constitutional obligations to investigate the matter before they throw out these unsubstantiated averments. And so for all of those reasons, Deputy Chief Justice, our respectful submission is, it's a very narrow point. The narrow point is there any basis for this court to find that Hatton was authorized by HBU to trade on its behalf? And our respectful submission is there is no basis for that. And once that's the case, the whole case against HBU simply implodes. Because if there's no authority on behalf of Mr. Hatton to trade on behalf of HBU, the whole case simply ends. Deputy Chief Justice, I wanted to make two other submissions. The first is regarding the procedure used by HBU. Well, we submit that it was an appropriate procedure. If you listen to what I've argued, I haven't actually relied on any facts which have been put up by my client. I've relied on the Commission's facts. And so we respectfully submit that the use of an exception procedure was entirely appropriate. And then the very last submission on leave to appeal, we respectfully submit that this is an appropriate case to grant my client leave to appeal. And Deputy Chief Justice, I'll elaborate on those submissions if necessary, but those are my submissions. Thank you very much.
Thank you, Mr. Cockrell. We're then going to ask you some questions.
If there are no other questions, since you were cut off, you would have heard a number of your colleagues who are opposing the Commission's appeal saying that questions of the assessment of the adequacy of the pleading doesn't engage this court's jurisdiction. It's just a mundane question. If the appeal court misunderstood the facts, misread it, weighed them incorrectly, none of that engages this court's jurisdiction. Why do you say the CAC's alleged error in this case concerning your client engages our jurisdiction?
Yes, Justice Rogers, will you just let me find my notes in that regard, please, because there's a short answer to that. Yes, the Commission actually concedes it in their answering affidavit in Volume 12, page 111. The Commission's answering affidavit in HBU's application for leave to cross appeal, paragraph 20.2. The Commission concedes that the cross appeal of HBU raises both an arguable point of general public importance and a constitutional matter.
Well, we're not bound by that, and I'm not sure whether perhaps contentions were advanced in your application for leave to appeal which go beyond the point you've argued now. But what do you say is the arguable point of law of general public importance concerning the question whether the allegation of authority suffices?
It's the duty that binds the Commission to investigate complaints before making the referral in our respectful submission, Justice Rogers.
It's common cause that that must be done.
Yes.
You may say it wasn't done here, but we don't need to decide that the Commission as a responsible regulator should properly investigate before it refers.
We say it wasn't done, though. And
yes.
We say it wasn't done.
What's the point of law we must decide, or do you say that's a constitutional issue?
It could be a constitutional issue with respect, because it's feeding into a broader debate regarding the duties that attach to a regulator before advancing unsubstantiated averments against respondents. And so we say it's a constitutional matter because it's dealing with the issue of what duties attach to an organ of state before they make these sort of averments. So it would be a constitutional matter in our respectful submission.
Yes, I'm not sure all your colleagues for the respondents will like that answer, because then we would have to say that all the allegations about insufficiency of pleadings against them also raises a constitutional matter.
That's the answer I give for my client, for my client, Justice Rogers. You know, if we need to go into the non-constitutional matter, The issue would be, well, it's just a variation on the theme. The issue would be the Commission makes the allegation, but there is no basis to support it. But that's just a variation on the theme, Justice Rogers. I'm not sure I can take it very much further than that.
I mean, is the question whether it suffices for the Commission merely to allege somebody's authority, or whether they need to... Do you say there's any doubt on the law? Rule 15.2 requires the pleading of material facts.
Yes.
A statement that somebody is authorized, I think on the face of it, is a conclusion.
Yes.
Authority can flow from a variety of different facts. The question is, what is the material fact which justifies the conclusion that somebody is authorized?
Yes.
But Rule 15.2 is clear that material facts must be pleaded. So it doesn't appear that there's a question. We don't have to interrogate the proper interpretation of Rule 15.2, but we'll hear from Mr. Nkatobi for the Commission. Maybe he says a mere bare allegation of authority does suffice, and maybe that will raise a question of law that we must decide.
Yes.
As to the scope of material facts for purposes of Rule 15.2.
Yes. Justice Rogers, may I make it clear? I assumed it was common cause between us and our learned friends that the issue raised in the cross-appeal was a constitutional issue.
Yes, but
I accept that you are not bound by that. Of course I accept that. But the dispute between us and my learned friend is effectively a non-dispute, because the Commission concedes that it is a constitution, it is a matter raising a general matter of public importance.
thank you.
Mr. Cockrell, in respect of what HPEU calls a dismissal application, isn't it really complaining about non-compliance with Rule 15.2?
Yes.
Isn't that properly then an exception?
Justice Theron, may I just try and get clarity on where the question is going? Is the concern about the matter not being appealable, or is there some other concern that you want me to address?
Do you want to address my questions that may still arise? Or I'm not sure why you're asking the question.
Yes. No, I'm just trying to get clarity and trying to shorten the debate.
I'm trying to understand what is a dismissal application. Trying to understand where provision in the rules of the tribunal is made for a dismissal application.
Yes.
When the complaint relates to non-compliance with Rule 15.2 of the tribunal.
Yes.
And if that's the complaint, then an exception should have been filed.
Yes. The proceedings brought by my client HPU was not a pure exception. It was a quasi-exception, if you like.
Then why didn't they file it as a quasi-exception? Why bring a dismissal application which none of us seem to be familiar with?
Because of the history of the matter, Justice Theron. So there's a long history of the matter which is set out in our heads of argument. We've tried to give you a potted summary of that. So the reason why this dismissal application was brought was because the CAC gave the Commission a second chance to plead these averments and to plead them properly. And when that invitation was not accepted by the Commission, my client considered the only way to secure appropriate relief was to ask for a dismissal application. Now, the dismissal application was formulated as a dismissal application, but in the alternative, declaratory relief was sought to the effect that the Commission hadn't complied with the relevant tribunal rules. So that alternative relief would also allow us to come home if the court were of the view that the dismissal was inappropriate. But our primary submission is, in the light of the history of the matter, in the light of the fact that all of the invitations by the tribunal and the CAC had been spurned by the Commission, it was appropriate in our submission for my client to ask for the matter to be dismissed. That is our submission in a nutshell.
If we have to allow parties to have regard to their matters and the history of their matters,
Yes.
and circumvent compliance with the rules, that would lead to some kind of chaos, would it not? Surely, if you want to bring a procedural challenge, you must do so in terms of the rules. If you want to bring an application, or any application must be brought in terms of the rules of procedure.
It's not.
And it just doesn't seem to have merit to justify circumventing the rules on the basis of the history of a matter.
But Justice Turan, with respect, the history is critical. So may I try and answer your question this way? If one tries to straitjacket HBU's application, you may say, well, it wasn't formally an exception. But with respect, the tribunal doesn't work in those rules. So the approach of the tribunal is not to straitjacket the parties into bringing an exception within the meaning of the rule. And the tribunal has been quite clear in other cases that it is more than prepared to give the parties the latitude to bring other applications that are just and equitable within the meaning of the rules, even if they are not exceptions proper. And in this case, the tribunal had no quibble with the fact that my client asked for a dismissal application. And indeed, Justice Turan, if you look at all of the other respondents who are in the room, most of them here also didn't bring exceptions proper. I can't say most of them, some of them didn't bring exceptions proper. So if you were to find that my client utilized the wrong procedure, you would also be, in effect, be making a finding that in the case of the other litigants, they also used the wrong procedure. But our fundamental submission is this: the tribunal is not straitjacketed by procedure. Its rules are more flexible, and it was entirely appropriate in this case for my client to ask A, for dismissal, alternatively for a declarative that the rules had not been complied with.
If I understood your earlier submissions, Mr. Cockrell, you said that what is missing is the factual basis for the averment that Mr. Hatton had authority to bind HBEU.
Yes.
And that basically would justify HBEU to bring an exception. But anyway, let's move on.
Yes.
If I recall the papers correctly, HBEU does not rely on an arguable point of law for jurisdiction in this court.
Justice Turan, I don't want to make my learned friend's life more difficult, but his concession was both legs of the jurisdictional.
I'm not asking about his concession. I'm asking about HBEU's case.
I'll have to ask my learned junior just to look that up. I don't want to waste the time, but I just can't recall, quite frankly, Justice Turan.
Because, like Justice Rogers, I would have difficulty, or I have difficulty finding the arguable point of law or the constitutional point that arises in this matter.
Justice Turan, I don't have the record to hand. I'm going to ask my learned junior to look that up, and perhaps I can come back to you about that in due course, if I may.
Yes, you may.
Make it clear, I'm not trying to duck the question. I just don't want to waste the court's time there.
Yes. Yes, you can address it later, Mr. Cockrell. Those are the only questions I have for now.
Come back to Justice Turan.
Yeah, Mr. Cockrell, while they're checking there, can I ask you, may I just say on jurisdiction, just to add to this, I got another question on your argument. On jurisdiction, it seems to me your argument is based mostly on this, that the CAC got the factual analysis wrong as far as Hatton is concerned, and as far as Mijo Merkovich is concerned.
Yes.
Isn't that beyond the scope of our jurisdiction?
Well, if you strip out, if you boil away the bluff, the complaint is that HBEU was not treated the same as the other respondents, even though they were similarly placed. And it's that lack of equality of treatment that ultimately would ground the constitutional complaint. The complaint is that the CAC ought to have drawn a similar inference in the case of all of the banks, but it drew the inference against HBEU, but didn't draw a similar inference against the other banks, even though the facts were effectively the same, Justice Majid.
Well, that's actually my question that I want to ask you.
Yes.
There's no authority. Let me rephrase that. There is authority in this court that similarly placed litigants are not entitled to a similar outcome. That's Metcash.
Yes.
So you can't, because a litigant in a certain position has been treated like this and you've been treated differently, say then that you're entitled to the same outcome. How does Metcash affect this argument that you say, because there's a different outcome, therefore the court has jurisdiction?
In Metcash, there were two different courts, Justice Majid. In this case, it's the same court. So the same court, dealing with the same record, draws the adverse inference against HBU, but doesn't draw the same inference against the other banks. So we would respectfully submit that Metcash is distinguishable on that basis. It's the same court. It's the same court.
I would have thought the principle would be the same, remain the same, even if it's the... I would have thought the principle would be the same, even if it's the same court.
But that's the complaint. The complaint is that my client was unfairly treated, if I can put it that way, precisely because the CAC drew the inference against my client, but didn't draw the same inference against other banks on exactly the same pleadings. That is the source of the complaint.
And do you say that implicates its any constitutional right, and if so, which one?
Well, I need to just work, I need my learned judge to tell me whether the case was pleaded or not. I don't want to give an off-the-cuff answer which isn't the pleaded answer. So can I come back to you on that as well?
Yes, I must tell you, my notes here, my summary says that you pleaded both, but my note may be wrong, of course. Yeah. But anyway, that was the only question I had. Thank you, DCJ.
Mr. Cockrell, I'd be happy if you just make the submission that you pleaded both. I take your word for it. It's more likely I'm mistaken than you.
I'm sorry.
I would be happy to accept your word that you pleaded both a constitutional issue and an arguable point of law, and accept that I may have been mistaken. If that's your instruction from your junior.
Well, I'm not sure it is, and I wouldn't want to mislead the court. Yes. So I'd rather give you chapter and verse, Justice Tarani, if I may, just so that it's not my mistake.
Should we give you some minutes, Mr. Cockrell? Or you'll deal with it in reply? Huh? Mr. Cockrell? You mind dealing with this issue in reply, or have you found something?
I've been given a reference which is not a helpful reference with respect, Deputy Chief Justice. So may I deal with it in reply? So
you make your election now. You want to deal with it in reply?
Yes, I don't want to waste the court's time. So if the short question is, was that point pleaded or not, I'll be able to address that very quickly in reply.
Okay.
Maybe that would also deal with your question, Justice Majid. I don't know whether it will, but hopefully it will be.
Okay. Thank you very much. That will be all for the moment. Advocate Mubai Toby.
Could I argue from Mr. Cockrell's notes? Thank you, Deputy Chief Justice. I think that let me probably shorten this. My learned friend relies on three things when he says that the Commission's pleaded case is deficient. Let me deal with each one of them. The pleaded case on the authority of Hartin. Let me just focus on Hartin and forget about Mijo for a second. The first authority that he cites is ESCOM versus Soweto City Council, which is a judgment they gave us yesterday. It's reported in 1992, volume 2, SA 703. It's of the old Witwatersrand local division, a judgment of Fleming DJP. Regrettably, it's irrelevant to what we are dealing with here. It is a case about whether a person who institutes proceedings on behalf of a juristic entity has shown authority to bind the juristic entity when instituting proceedings. And there, the deponent it had stated that he was authorized to make this affidavit. And then the argument was that is different from authority to bring the application. And that's a totally different issue. It's an authority to bring proceedings. It has nothing to do with the authority to enter into collusive agreements in the competition sense. So case number one is irrelevant. Case number two that is referred to is Gralio which is a competition appeal court case. It's a judgment of Dambuza J.A. The relevant part, it's at page 1693 of the authorities bundle. It's in paragraph 12 where there is some relevance. It was an issue about the trial. So the trial, a cartel trial, had run its course, and one of the defenses of the alleged cartelist was that the person who concluded these agreements on my behalf was not authorized. And that is what they dealt with in paragraph 12. The tribunal found that there was no evidence that the respondent had participated in the alleged concerted practice, and further that the appellant had not proved that Hansen had authority to represent the respondent and to agree and bind it in the participation of the cartel activities. The tribunal also found no basis in the evidence from which it could be inferred that Hansen had or would have conveyed the resolutions or agreements concluded at the cartel meetings to those in authority within the respondent. So again, that is irrelevant to the question of pleading authority at exception stage. Then the third one is then Rule 15.2. And the basis for invoking Rule 15.2 is that it says material facts must be pleaded. 2 days ago, we relied on the judgment of the Supreme Court of Appeal, which answered this issue, that the pleading that a person is duly authorized is sufficient to withstand an exception. That's the, not C, I think. Just want to get the name of that case now, as escaping.
View Shopping Center?
Yes, Northview Shopping Center, paragraph 28. Now, the question then is, that was a judgment deciding sufficiency of pleadings under Rule 18 of the Uniform Rules of Court. Under Rule 18 of the Uniform Rules of Court. Now, Rule 18.4 of the Uniform Rules is worded identically to Rule 15.2. Your pleading must contain sufficient facts, material facts, not sufficient, material facts. And that has already been interpreted to mean, in the context of an exception, it is a sufficient material fact to say that a person is duly authorized to take a particular action. So that would actually be dispositive of the entire debate about Rule 15.2 and the material facts. And then the final thing to be said about this is that the actual pleading in relation to HBEU, which is the United Kingdom entity, explains the basis for drawing the inference that they were duly authorized. And that is at page 472. So it's actually not a bold averment. So it's 471 from paragraph 303 and 472 at 304 and 305. It says in 305, the 14th and 19th respondents are members of the same group of companies and are therefore directly or indirectly linked to one another. Now one can say, I don't like that way of attributing authority, but one can never argue that authority is not factually pleaded. What is the basis for inferring authority? So what that means is that the three arguments that have been raised, none of them actually can be sustained. When we then go back to Hutton, what we know is there is a group of companies under HSBC. The Commission has some facts that implicate HSBC, and then it pleads in the alternative. You are either employed or duly authorized. The fact that the UK entity did not employ is irrelevant. It does not mean that it did not authorize. And the question whether it did or did not authorize is a question of fact that will be decided, like it happened in Gralio, at the trial. It is not something to be dealt with at exception. Thank you, Deputy Chief Justice.
Thank you very much. Advocate Mukatobi, I think my colleagues, if they've got questions, they will ask you. Okay.
Any rethink about the concession and jurisdiction?
No, I am not going to even do that. It will bite me tomorrow in another case. So.
Mr. Mugaitobi, the complaint really is that the Commission did not comply with Rule 15.2. It didn't make, and this is specifically now in relation to proceedings in the Competition Tribunal, that it didn't comply with the rule that says that it should not just reach legal conclusions, but make a factual basis to support the legal conclusion. What do you say about that?
Yes, that we say, based on SCA authority, it's the same wording, Rule 18.4, place material facts. The question is, when you say you are duly authorized to enter into an agreement, is that a material fact sufficient to meet an exception objection as per Rule 18.4? The SCA authority on that point is clear. You then come to the competition context. The exact same wording is used in Rule 15.2. And that authority would then be dispositive of that question. It would be sufficient to say this person was authorized by this entity to enter into trading. But in the course of that, they abused that authority and entered into collusive agreements. And then I say, in addition to that, the factual basis for that authority is set out in the pleading, because it is explained that we say he is authorized because he is representing a company that falls within a group of interrelated sister companies.
And the applicant accepts that it's not sufficient for the link between HBEU and the other HBUS that can be drawn simply because Mr. Hatton worked for a company within the same group, that the Commission accepts it has to go further, and this is why I would assume it's relying on the authority.
Yes, that's why we rely on the authority. The problem, of course, you find, Justice Teron, in these sort of things where somebody breaks the cartel. That's what typically happens. They break the cartel, and they decide, let me go and confess. And then they give you information, some of which is cryptic, because that's how a cartel operates. And what you see in that information is that it refers to HSBC, and HSBC comprises of 4 companies. You are perfectly entitled to say Company A, because they're all in the same stable, Company A or Company B or Company C, and then say the trial will sort out whether or not that trading did not benefit the UK entity. It's not appropriate at exception stage to try and defeat it.
Yes. Thank you, Mr. Mukatawi. Thank you, Chief Justice.
Thank you, Advocate Ngotobi.
Thank you, Justice.
Thank you. Advocate Cockrell,
Yes.
do you have a reply?
Thank you. Justice Turon and Justice Majid, I said I would come back to you about the pleading. So it's paragraphs 49, 50, and 52 of the application for leave to appeal. And you'll find that on page 1081. So it's the application for leave to cross appeal of my client. I'm going to read it to you because it is also an answer to the substantive questions that I was asked. The issue consequently raises arguable points of law concerning the equal treatment of respondents and when a respondent's bank may be held liable for the conduct of a trader that it does not employ and who is not authorized to trade on its behalf. but who is employed by a different entity within the same group of companies. It also raises the question of what standard of pleading the Commission ought to be held by. The HBU submits that it has strong prospects of success. We don't need to go with that. In circumstances where the Commission may not know the identity of the firms within a group of companies, the Commission is required to exercise investigative powers properly and evaluate the alleged contravention. It is not permitted to adopt a shotgun approach, citing the firms within a corporate structure in the hope of correctly citing someone. It is this failure to exercise its powers properly, which is a matter of general public importance and which ought to be properly considered by this court. It also raises the constitutional issue as it concerns the Commission's exercise of its powers. And then in paragraph 52, the conclusion, I therefore submit that the issues in this cross-appeal raise both, and I would interpolate, a constitutional issue and B, an arguable point of law of general public importance. So that is the response as a matter of pleading. And as a matter of substantive law, what I would say is, it's, with the greatest of respect, in competition proceedings, it's not enough to get by with a skeletal averment of authority. The whole point of the Competition Commission is that it has vast powers to investigate, and if it's going to discharge those duties properly and diligently, it must investigate whether HBU did in fact authorize Hatton. What we know from the record is that there was not a single question asked to HBU in that regard. So the Commission stood by its guns, it stood by the pleading. My learned friend now says, well, he can get away with that because of the SCA judgment that he cites. But with respect, in the case of competition matters, one would expect something more of the Competition Commission, rather than to get by with a bald allegation of authority. And that bald allegation of authority has led to all of the consequences that you've heard. 8 years later, my client is still facing a complaint. My learned friend says, well, maybe he'll be able to prove the authority in due course. But if he doesn't, the expenses are going to rack up. And that is simply something that should not conscionably be permitted by a regulator in our respectful submission. Deputy Chief Justice, that is the response to the matter of substance my learned friend raises, and also to the matter of pleadings that Justice Theron raised. That's it. Thank you.
Mr. Cockrell, you know what worries me about this stage of the matter is that we're at exception stage. And shouldn't we be worried with wanting the Commission to give evidence and to give proof at this stage? Yes, at the trial stage, they would have to give those. But I'm just worried that we're at an exception stage.
Yes.
And all that 15.2 requires is concise statement of facts.
Yes.
And I'm thinking that if all that the Commission could say at this stage is that Hatton was employed by one of the companies within that group,
Yes.
then during the evidence stage, and probably at that stage, there would be discovery proceedings as well, and there would be probably a pre-hearing meeting and all of that. All those things will become clear. I'm just worried about us in this court saying that the Commission has to give more than it has given in this matter. And I'm worried that we would be treading onto evidence.
Yes. Justice Cheeky, I understand the concern. It's a concern that has reverberated throughout this hearings, and I'm aware of the concern. What I would say is, just look at how narrow the dispute is. It's common cause that H-Bus employed Hatton. That is common cause, not disputed on the pleadings. The only dispute is not whether HBU employed Hatton. That's not a case the Commission relies on. The only dispute is whether, even though Hatton was employed by H-Bus, not by HBU, was Hatton nevertheless authorized to trade on behalf of HBU? That's how narrow the dispute is. And that is the issue that is going to have to be ventilated in a trial. And in our respectful submission, it's not inappropriate for this court to cut through all of that and say, the Commission had the powers to investigate the authority of Hatton. It was required to investigate whether Hatton was authorized by HBU. I've made the submission. The deponent says that HBU authorized Hatton, but the deponent couldn't have any knowledge of that, and the deponent doesn't claim to have any knowledge of that. So it's a throwaway averment, and on the basis of that throwaway averment, in our respectful submission, our client will have to sit through the competition proceedings in due course. And it's that outcome that we seek to avoid with respect. I'm alive to the concern. I really am very much alive to the concern. But I've tried to make the dispute as narrow as I can. The sole issue is whether HBU gave authority to Hatton to trade on its behalf. That is as narrow as the dispute is. If you find yes, well, then my client is in for the long haul. If you find no, my client is off the hook. And that is ultimately the matter that you are seized with.
So we should take prejudice to your client when we're deciding this fact?
Yes, very much so. The prejudice is made out on affidavit. The prejudice is made out that my client has suffered 8 years of this complaint already, and the complaint is going to continue. That is the case made out in our affidavit, Justice Nchiki. Yes.
Okay, thank you, Mr. Cora.
Mr. Cockrell, would it make any difference to our approach if, say, for example, we uphold the Commission's appeal in respect of HBUS,
Yes.
so that it's going to be in the case anyway,
Yes.
at least up to now represented by the same team?
Yes.
If you have to be there just to also safeguard HBEU's interests, it then would seem not to be such an inconvenience to be part of the trial?
Yes. Justice Rogers, there are a number of counterfactuals built into your question. But if the question to me is it a great inconvenience to my client if it has to sit through the trial, having me represent HBUS and rather than HBU, the answer is no.
Or both?
Yeah.
Yes.
Or both, but
Yes.
Presumably, well.
Can you just remind me, what is the position under the Competition Act in respect of costs against the Commission? If the Commission is found, that this might not affect your only client, but the Commission's deponent in the referral affidavit says that he verily believes all the facts in his affidavit to be true.
Yes.
So he verily believes certain facts about the employment, he
Yes.
verily believes that Brown Rig traded.
Yes.
Wasn't, for example, for Standard Bank. If it emerges at the end of a trial that none of that sticks and that the allegations were made recklessly, can the Commission have costs awarded against it? And might that also be so in respect of your client? If you have to sit through a 6-month trial only for it to be conceded at the end of the case that the Commission never had any basis to allege that Hatton was authorized to trade on behalf of your client, would you be entitled to get your costs against the Commission?
Justice
Frivolous or reckless
Yes.
litigation?
I'm answering off the hoof. I just can't find the relevant section. But in fact, let me not answer on the hoof. Let me give you the relevant section, if I may. Justice Rogers, I don't want to waste your time. My recollection is there's a hard rule that prohibits costs against the Commission in the Tribunal. That's my recollection. It's different on appeal, but there's a hard rule that prohibits costs in the event of even.
So it becomes all the more.
Yeah.
It becomes a matter of the healing balm of costs, as somebody was wont to say, is not available to a respondent in the Tribunal.
Yes, and when I say it's a hard rule. It's a hard rule which doesn't permit an exception, even in the case where the Commission has been recalcitrant or has been dilatory in the way in which it's performed its investigative functions. So it's furthering your point, Justice Rogers. If my client can't get the healing balm of cost, he's going to have to sit through the hearing without the prospect of recovering costs against the Commission in due course. And that's my recollection of the rule, Justice Rogers. If I've got it wrong, I'll do my best to correct it. But the last time I looked at that, it was an exclusion which had hard edges. There were no furry edges to the rule about costs.
There's, we directed that the parties wouldn't go into the question of simultaneous appeals and reviews, and I'm not sure, I suspect your client isn't one of those that brought a review. Yeah. But, for example, the making of allegations for which there is no foundation, even if they pass the pleading muster,
yes.
Might be a separate basis for a review.
Yes.
To prevent a litigant, I know Standard Bank has a pending review.
Yes.
That might be a way of addressing allegations for which there is no foundation and which weren't investigated.
Yes, yes. Yes, it may be. We didn't consider a review, Justice Rogers.
Yes. Thank you.
Sorry, Justice Rogers, the section I was battling to find is section 57 of the Competition Act. Do you have it, Justice Rogers?
The Act?
Of the Act,
yes.
Competition Act. Section 57(1), subject to subsection 2 and the Competition Tribunal's rules of procedures, each party participating in a hearing must bear its own costs. And to the best of my recollection, the exceptions in subsection 2 don't assist. So the hard rule is each party bears its own cost in the Competition Tribunal.
Thank you. Thank you.
Thank you.
Mr. Cockrell, just coming back to this duly authorized point, in Northview Shopping Centre, the SCA said, if you plead at exception stage that the person is duly authorized, that's adequate. Then says, you could still raise authority in your plea, you could deny authority, and you've got to specifically plead it because it's a specific, it's a special defense, denying authority.
Yes.
Now you say that's not adequate for competition law. It may be good law for normal civil cases, but not for competition law cases. Is there any authority that says that for competition law, even though these two rules read exactly the same, 18.4 and 15.2, is there any authority that for competition law cases you must do more than just deny authority? Or put it differently, that for competition law, you must go further than you would do for ordinary civil cases?
There's no authority of which I'm aware, Justice Majid. The only authority that's come closest to it in our respectful submission is the Soweto City Council case. So in that case, I understand the facts were different, but in that case, even it was the High Court, not the SCA, so I accept the SCA ruling would take precedence.
Sorry to interrupt you, but isn't there a further problem? It's an ordinary civil case, it's not a competition case.
Yes, no, it certainly is, it's an ordinary civil case, but we respectfully submit that the same reasoning would apply. So nothing turns on whether it's a competition matter for this particular submissions. And what the court said in that case is, it's a factual question whether a particular person holds any specific authority. It may be proved in the same way as any other fact. So we would say the Commission makes the averment. The Commission now has to offer some credible basis for that averment, and that's what they haven't done. I understand that we are at the exception stage in inverted commas. I understand that we aren't at the trial stage. But with respect, the same reasoning should apply in our submission. The Commission makes the averment. I would be surprised, let me put it no higher than that, I would be surprised if the Commission has any basis for making the averment that Hatton was authorized by HBU. And now the Commission says, not my problem, it's a problem for some later stage. It just...
But as I understand it from what Mr. Ngatobi told us earlier, ESCOM was a case which concerned the authority of somebody to bring an application. In other words, it moved beyond the preliminary stage, if I may call it that. It was actually an application now in court, and that deponent to the affidavit's authority to bring the application as opposed to making an affidavit was challenged. So isn't it a big difference that we're now at exception stage here?
It certainly is different. I accept that, Justice Majid. What I would say is the averment is made by the Commission, authority of Hatton, and for similar reasons of underlying principle, in competition matters at any rate, The Commission should have some basis for making that averment, and if not, my client shouldn't be made to sit through the trial procedure.
Thank you. Thank you, Mr.
Seems to be it. Advocate Cockrell.
Thank you.
Thank you very much.
Thank you.
We now move to the Credit Suisse appeal. Advocate Norton.
Thank you, Deputy Chief Justice, Justices of the Court. The key issues that arise in Credit Suisse Securities application are first, whether the Commission has pleaded sufficient facts to establish that the Tribunal has jurisdiction over it as a foreign peregrinus, and second, whether the Commission has initiated a complaint against it in accordance with Section 49B of the Competition Act. The jurisdiction ground of appeal arises from an error made by the Appeal Court in determining whether the Commission's pleadings established the Tribunal's personal jurisdiction over Credit Suisse. As we have heard, the Commission in its referral divides the respondents into three groups. First, what it calls the South African respondents, the South African banks. Secondly, the local Peregrini respondents, foreign banks alleged to have a presence in South Africa. And third, the foreign Peregrini, foreign banks not alleged to have any presence in South Africa. The Commission pleads in its affidavit, in its amended referral at paragraph 4911, that Credit Suisse is a foreign peregrinus. That is also a common cause in the Commission's application to join Credit Suisse to the referral. In the first round of interlocutory proceedings in this matter, the Tribunal found that the Commission had alleged sufficient facts to establish the Tribunal's jurisdiction over 7 local peregrini, and the Appeal Court did not disturb that finding. In respect of the foreign peregrini, the Appeal Court held that personal jurisdiction must be established in accordance with the connecting factors test. Now, when this matter reached the Appeal Court in the second round, the Appeal Court considered whether the Commission, on the new case now pleaded in its amended referral, had pleaded sufficient facts to satisfy the connecting factors test. It held that in the case of foreign peregrini not alleged to have been part of a conspiracy in which they participated with South African banks directly, the Commission had failed to plead sufficient connecting factors. There were 3 foreign peregrini who fell into this category: the 19th respondent, HBAS, the 20th respondent, Merrill Lynch, and Credit Suisse. Each of these respondents is alleged to have had interactions only with foreign banks, and indeed with the same foreign banks. None of these respondents is alleged to have had any contact with any of the South African banks. The 3 respondents, Justices, are similarly situated in every key respect. The Appeal Court held that the Commission had failed to plead sufficient connecting factors in respect of Merrill Lynch and HBAS because it had not pleaded facts to connect them with any South African banks. But when it came to Credit Suisse, the Court took a critical misstep. It said at paragraph 139 of its judgment, CSS is a local peregrinus and only subject matter jurisdiction is required in this case. But Credit Suisse is a foreign peregrinus, and the Tribunal's jurisdiction over it should have been determined on the same test that was applied to Merrill Lynch and HBAS. The Court would then have found that the Commission has not alleged any interactions between Credit Suisse and any of the South African banks, and has failed to plead sufficient facts to establish the Tribunal's jurisdiction over Credit Suisse. We say this was a patent error by the Appeal Court. Now, the Commission, in response, does not dispute that Credit Suisse was wrongly treated as a local peregrinus. or that the appeal court would have upheld Credit Suisse's appeal if it had treated it as a foreign peregrinus. Instead, it resists this appeal on three alternative grounds. The first is that the jurisdiction requirements determined in the first appeal court decision were wrong, but that, of course, is to resurrect an issue that was determined by the appeal court in the first round. And for all the reasons that we've set out in our written submissions, we say that the jurisdictional requirements applicable to foreign peregrini are therefore res judicata. But if the Commission is permitted a rerun of its Section 3.1 argument, we submit that that argument is in any event unfounded. Section 3.1 gives the Act a broad scope of application, but the Tribunal's jurisdiction must be determined in the light of all the relevant provisions and principles. And here the connecting factors test adopted by the Appeal Court achieves at least two objectives that Section 3.1 on its own cannot. The first, by requiring the Tribunal to consider whether it is the appropriate forum, it ensures that the Tribunal will exercise the necessary moderation and restraint in cases having a foreign element. This was something, a consideration identified by the Competition Appeal Court in the Anzac matter. And so comply with considerations of comity, which, as this court recognized in the case of South African Human Rights Commission versus Standard Bank of South Africa, may dictate that a matter is best left for adjudication by a foreign court that has a closer connection to the matter. One might consider if this case had in fact involved only the foreign firms said to have been involved in the old Gits chat room in New York. One would have wanted the Tribunal to ask itself, if we have firms and conduct in a chat room in New York involving conduct regarding the US dollar South African rand currency pair, and in circumstances where the New York authorities have taken steps to prosecute the very same conduct, is this the appropriate forum? And that, we say, the connecting factors test does, because the first step is to consider with moderation and restraint the question of appropriateness. Second, the connecting factors test ensures that the Tribunal's orders would at least be capable of enforcement by the High Court, because the test is consistent with the requirements governing the High Court's own jurisdiction over foreign peregrini, the test laid down in Strang, which has indeed been followed ever since. The test therefore promotes the effectiveness that's foundational to the rule of law, although it must be borne in mind here that what is envisaged by the principle of effectiveness is not that a court or a tribunal can in fact make an order effective against a particular respondent, even a respondent which is an insular in a particular jurisdiction, but that the order is at least capable of being enforced. The Commission's second contention is that if it is bound by the connecting factors test laid down by the Appeal Court in its first decision, it was not required to plead direct contact between foreign peregrini and South African banks. But the Appeal Court did not dream up this requirement. It arises from the Commission's own pleading in the amended referral. The Commission, we've seen this before, pleads in paragraph 50 that the Tribunal has personal jurisdiction over the foreign peregrini by virtue of two connecting factors, the second one being that they participated in a conspiracy together with the South African respondents. Now, it did so because it had told the Appeal Court in the first Appeal Court proceedings that it was not prosecuting separate cartels, some involving only foreign banks, but an SOC involving South African banks. Thus, it had in its pleading net banks and conduct that were squarely within the tribunal's territorial jurisdiction, and it needed to pull the foreign banks into an SOC with those banks. This it could not do by relying only on the involvement of the South African Rand. Having pleaded that the respondents were in a conspiracy together with the South African respondents, the Commission was then required to plead facts from which it could be established or plausibly inferred either that the foreign peregrinus had direct contact with South African respondents, or it had actual or imputed knowledge that it was participating in a conspiracy that involved the South African respondents. We say that's the very least that was required on its own pleading. It's also what is required to establish its cause of action, in line with all the jurisprudence on single overarching conspiracies that it relies on. But the Commission has not pleaded any facts that would support either proposition. In respect of Credit Suisse, it pleaded 8 conversations with the traders of 4 foreign banks. The Commission's third line of defense is to contend that Credit Suisse was connected to the South African banks through its connection with Mr. Katz, but the Commission has not pleaded any facts from which it could be plausibly inferred that Mr. Katz connected Credit Suisse to the South African banks. The final string to the Commission's bow is a late-in-the-day suggestion that the direct contacts requirement is met by its averments that Credit Suisse's representatives had interactions with respondent banks that are local peregrini. But, Deputy Chief Justice, the presence of a branch office in South Africa, which is not alleged to be implicated in the conduct of the SOC, does not render a non-resident bank a South African participant in the SOC. Deputy Chief Justice, we submit that the Appeal Court ought to have found that the Commission has failed to plead sufficient facts to establish the Tribunal's jurisdiction over Credit Suisse. We say that the issues raised by this ground of appeal fall squarely within this Court's jurisdiction. The Appeal Court's failure to treat Credit Suisse as a foreign peregrinus resulted in its application of the wrong legal test to determine personal jurisdiction, and it resulted in Credit Suisse being treated differently to other respondents in exactly the same position. We submit that the Appeal Court acted contrary to its duties under the rule of law, under Section 34(1) of the Constitution and Section 9(1) of the Constitution, first to give proper consideration to the issues and facts before it, and secondly, to apply the law consistently and uniformly, and to apply the same laws without discrimination to all persons who are similarly situated. We refer the Court in this regard both to its recent decision in Vodacom versus McCarthy, and also to the decision of this Court in Metcash, referred to earlier by Justice Majid. And there we draw the Court's attention to the paragraphs 18 and 25 of that judgment, where a couple of points were made which made it clear that Metcash did not close the door to an argument before the Court that in this instances the respondents were entitled to be treated alike. There, the Court held that was dealing with 2 different panels, determining reasonable prospects of success on appeal, exercising a discretion where the Court said different panels could reasonably come to a different conclusion. But in paragraph 18, left the door open to say that even in that situation where you were dealing with different panels and not the same decision maker, if the difference in treatment was based on irrational or arbitrary decision making, it might lead to a different result. We also say that the interests of justice favor the hearing of this appeal, and we have covered those in our written submissions. I'm going to deal very shortly with our initiation ground of appeal. The Commission applied to join Credit Suisse only after the original referral. It was joined after the amended referral. Whether that was competent has been addressed by other counsel. The issue raised by Credit Suisse's appeal is what this court decided in Pickford's. Did it decide, as the Commission argues, that once the Commission has initiated a complaint in respect of prohibited conduct, it can refer a complaint to the Tribunal against any firm alleged to have participated in that conduct without first adding that firm to the complaint initiated, whether formally, informally, expressly, or tacitly. And we say that this court in paragraph 21 of Pickford's recognized expressly that the initial omission of a firm at a stage when the complaint is first initiated and its subsequent addition to the complaint are not fatal. That's not what happened here, and for those reasons we also submit that Credit Suisse has not been valid, there's been no valid initiation of a complaint against Credit Suisse.
Thank you, Advocate Norton. Any questions?
Ms. Norton, you may have dealt with this, but I didn't get it. On the one criticism is the initiation was not proper against the client. And you also submit that the pleading was required to provide that it was in contact with South African banks.
That's correct, Justice.
I'm asking that I would like us to focus on 138 of the CAC judgment. And all I want to ask is whether the way it captures your submission and the response that it gives, whether you've got comment on that.
Justice Cheeky, paragraph 138
Paragraph 138
of the
first three sentences.
the first Competition Appeal Court judgment, or the second?
The second one.
The second. Okay. 38.
I printed the judgment, so I'm not able to assist you with where to find it in the record.
CSS's counsel submitted that the Commission case illustrates that it was predominantly in communication with Peregrini banks. That's, yes, Justice Cheeky, I see where you are. However, Barclays Capital was also in the old GITS chat room. Evidence suggests that the representatives of Barclays and Citibanks, which are local Peregrini, were also present in the chat room. Standard Chartered also had an agreement with the Commission. It too had an office in South Africa.
Yes.
Justice Cheeky, what the court appears to have been saying there is, you've come and told us that you were just in a chat room with foreign banks.
Yes.
Actually, those foreign banks also had offices in South Africa. And we submit that is not sufficient basis on which to draw any link between Credit Suisse or any other of the parties in the old GITS chat room with the South African respondents, because remember what the Commission pleaded was participation in a conspiracy with the South African respondents, and the Commission itself identified what it meant by that term, the South African respondents, early in its pleadings, and it was the 8 South African banks. Links with foreign banks which happen to have a representative office in South Africa, which are not implicated in the trading at all, we say are irrelevant to the issue.
Okay, thank you, I understand now. And then the other one point that I would like you to respond to is 139, concerning the intensity of Hatton's involvement in the chat room. That's one of the factors that the CAC seemed to find against you.
Yes, Justice, thank you for that question. Our point is not whether or not there was intense involvement in the chat room by Credit Suisse's traders, alleged traders. Our point is that in order to tie Credit Suisse into the SOC pleaded by the Commission, in other words, an SOC in which it participated with South African respondents, those relevant facts have simply not been pleaded. And so we don't begin to look at whether there are sufficient, we don't begin to look at questions of participation, the intensity of participation. We accept that the Commission has pleaded sufficient facts to establish that Credit Suisse had traders in the old GITS chat room. But the point that we argue before you, as I said earlier, this is not a case where the Commission, and it's interesting to imagine if this were a case where the Commission actually was just prosecuting the participants of the old GITS chat room before you today. This is not that case. And this is a case in which, and we say that the Commission would likely have been turned back at an early stage on the basis that there simply wasn't a link. Insofar as it relies on the South African Rand, that wouldn't have been enough. Because, in fact, we know that the New York authorities prosecuted the conduct in the old GITS chat room involving the South African Rand US dollar pair, currency pair.
Thank you.
Thank you, Justice.
Ms. Norton, should we also understand your submissions to be your client should have been treated similarly to HBC USA and MLPFS?
Insofar as the Competition Appeal Court found that if you're a foreign peregrinus,
Yes.
the Commission had to show connections to South African banks, and it didn't even apply that test to us because it made a mistaken assumption. It didn't have proper regard to what the Commission had pleaded, which was that Credit Suisse is a foreign peregrinus.
Yes, but I think what the questions Justice Chike put to you tell us what the CAC's reasoning was as to deciding differently as far as your client is concerned.
Well, it's not easy to follow, Deputy Chief Justice, because the CAC had said that it didn't need to apply to us the test that it applied to foreign peregrini. It then seemed to want to address a submission that had been made in the written submissions before it. And the submission was actually that Credit Suisse's traders in the old GITS chat room were alleged only to have been in discussions with American firms. And what the appeal court then wished to point out, and we say that nothing turns on it because they wanted to point out that some of these foreign firms had branches in South Africa. It's not clear what the purpose of adding that, what the court's purpose was in adding that rider. But particularly because the other respondents, HBUS and Merrill Lynch, were once again similarly situated. They'd also had chats with the very same banks that had offices in South Africa. So, as I said earlier on, these three banks are similarly situated in all material respects. And it was just by overlooking, disregarding the pleading of the Commission that Credit Suisse was treated differently.
Thank you for that. Oh, okay. Rogers, you don't have a question?
The argument that you advance is that the problem arose when your client was classified incorrectly, correct? And it seems that that incorrect classification may have had its foundation in the referral affidavit of the Commission. That
Sorry, no, Justice Colopin. The Commission had pleaded that Credit Suisse is a foreign peregrinus. The court didn't have regard to that and mistakenly treated Credit Suisse as a local peregrinus.
Well, in the affidavit at paragraph 46, it says the second class of local peregrini are the 11th respondent, Credit Suisse.
That's a different entity, Justice Colopin. That's the Credit Suisse group entity,
Okay.
which was part of the last proceedings, but not part of these.
Then my question is that in the judgment at 138 and 139, and you've dealt with that, the suggestion seems to be that your client's representative was party to chats with banks other than American banks, not so. That it extended beyond it.
No, Justice Colopin. Once again, the suggestion seems to be we the same chats, but now because the people that Credit Suisse, the banks that Credit Suisse was, the foreign banks that Credit Suisse was interacting with, also had some of them had a branch office or a representative office in South Africa, that those banks could no longer be regarded as foreign banks.
Yes. And you say that would not be sufficient in terms of the test that they would have had to apply, because you're saying they applied the incorrect test because they classified them incorrectly. The appeal court didn't even begin to apply the test to Credit Suisse because it proceeded from a wrong assumption. And so if it was other banks in South Africa, that would fall short because it would have to be South African banks in accordance with the connecting factors test.
And in accordance with the Commission's pleadings as to who the South African respondents were that it refers to.
Thank you.
Okay, that seems to be it. Thank you, Advocate Norton. I think we're going to take the lunch adjournment now. We're going to adjourn for 30 minutes, and then we'll come back. Thank you very much. Court adjourns.
If only, if Times talking about Hatton, I'm not going to expatiate any further. Secondly, this communication is in the old GITS. So this would then be the most perfect example to apply the doctrine in Woodlands, which is whatever else we have an issue with about initiation, whether one accepts our primary argument, which is initiation against conduct, includes participants to that conduct, or whether one then goes to the Woodlands asset initiation, where you don't know the firms, you name the one you know in Switzerland, and then it turns out the actual institution that did the trade is based in America. So we would say here the requirement for a tacit initiation is completely fulfilled. Yes, I'm told that it's not Woodlands, it's Yara. So that's why you have juniors, they correct you. But yes, Ms. Sigalala has corrected me. Thank you. Thank you, DCJ.
Thank you very much, Advocate Koreitobi. We'll check if there are any questions for you. It appears there are no questions.
As you please, thank you.
Thank you very much. Ms. Norton.
Thank you, Deputy Chief Justice. I'll deal with just two issues. The first, it was submitted by my learned friend that the error made by the court was an error of fact. Lest that be held against us in respect of determining whether the matter falls within this court's jurisdiction, I'd like to make a couple of submissions. The first is that what the appeal court did was not an error of fact in the sense that was contemplated in S versus Busak, for example. Here there was no assessment of the facts, there was no finding on the facts. It was simply a failure to consider what had been pleaded by the Commission, and in that sense cannot be regarded simply as an error of fact by the appeal court. And it was that the failure to properly consider what had been pleaded, as we've indicated, was also translated into a legal error in that the appeal court then applied the wrong legal test to Credit Suisse securities. As to paragraph 138 of the judgment, of the appeal court judgment, we make only the following point, that the court was clear that it was responding to the submission that Credit Suisse had only interacted with American banks. What it didn't say in paragraphs 138 or 139 was that foreign firms which are local peregrini because of a presence in South Africa could be, for the purposes of applying the connecting factors test, to bring Credit Suisse into the SOC or to bring it within the tribunal's jurisdiction, be regarded as South African respondents. And you have our submission there that is because what the Commission pleaded was a participation with South African respondents, and the Commission told us in its amended referral who those respondents were. If I could then just deal briefly with the initiation question. The court will have seen that there has been a shift in the Commission's case on initiation from the submissions made by Ms. Zikalala on the first day to what has been submitted today, because Ms. Zikalala submitted that there was an initiation on the 1st of April 2015 against conduct. It didn't need to be in respect of particular banks, it just had to be in respect of conduct. And after that initiation had been made, any banks later considered to be part of that conduct could be part of a referral to the tribunal. Today, Mr. Ngukai Tobi has submitted to the court this morning, earlier today, that the 1st of April, what happened on the 1st of April 2015 was a tacit initiation by the Commissioner against all the firms that might be part of the SOC that was alleged. But then that submission is at war with his subsequent submission today, which is that you must look at the amended initiation, which came a little while later, to see that Credit Suisse Group was added to the initiation of 1 April 2015. Now, the notion of what is tacit goes to what is in your mind and what is intended but not expressed. And if the Commissioner on the 1st of April 2015 had in mind that all the banks that might ever be drawn into this SOC were now part of this initiation, there would have been no need for an amended initiation, a formal express amended initiation a short while later. And then in a final submission, this court is told that actually you can take the amended initiation, and on the facts generously construed, you will find that that was the tacit initiation against Credit Suisse Securities, that in the second amended initiation, there was now a tacit initiation against other entities related to the Credit Suisse Group. And we submit that those submissions are at war with one another, and ultimately what we have in this instance is a party against which there has been no initiation whatsoever. Thank you, Deputy Chief Justice.
Thank you, Ms. Norton. Any questions? Appears there are no questions for you. Thank you very much.
Thank you, Deputy.
Thank you. Mr. Campbell, you are in the BNP Paribas appeal.
That is so, Deputy Chief Justice.
You may go ahead.
Thank you. Deputy Chief Justice, if I opened my submissions with the observation that the curtain raisers had now been played and it was time for the main game, justices of this court might, with every justification, think that I had taken leave of my senses and parted company with reality, because this application is, of course, by some distance, the narrowest and the shortest of everything that you've heard before. But that would be a fraction of the parting of reality that the Commission has undertaken in their submissions, which we'll get to shortly. Before we do, I just want to start with my grounds of exception, which of course are vague and embarrassing. And I start that, Deputy Chief Justice, paragraph 1 of my exception, where I simply set out the extracts of the pleadings that we say are vague and embarrassing and confusing. For completeness, that is at page 739 of the record. And the first one is that the Commission pleads a single overarching conspiracy between 2007 and 2013. The next version, which they tightened slightly, is with effect from September 2007 until at least September 2013. And I would ask justices to note that the words at least, of course, open that up. We don't really have an end point. But now the fun starts with the third extract. And that is, and I'm quoting, "The Commission does not know the date on which the single overarching conspiracy between the respondent banks ceased to operate, or if it has indeed ceased to operate." The fourth iteration is even more confusing. The Commission alleges that the conspiracy continued to operate using different modes of communication after September 2013, alternatively, after the implicated chat rooms were closed, further alternatively, after the respondents' traders no longer had access to the Bloomberg electronic messaging system. And I want to make it plain that we have no difficulty with the alternatives. It's the entire submission there. And the fifth is that the Commission does not know the date on which the overarching conspiracy between the respondent banks ceased to operate. That's similar to the third, but then they add another phrase, "if it has indeed ceased to operate." So they leave that open. Now, Deputy Chief Justice, the test, of course, in exception, is that we must accept that every allegation made in the referral is true and correct. That's the basis on which we judge the exception. So it is both true that the Commission does not know the date on which the single overarching conspiracy between the respondent banks ceased, and it is also true that it continued only until September 2013. And I have to ask the question as to why, if you don't know the date on which the overarching conspiracy ceased, then on what basis are you pleading that it lasted until at least September 2013? One of those allegations is plainly not true. Equally, you can't then, at the same time as you say you don't know the date on which it ceased, you can't allege that it continues to operate after September 13, which is the import of both the fourth iteration and the second. And you also then can't question the fact if it has indeed ceased to operate. Now, before I move on, I want to make a distinction between two different concepts, because in both the Competition Appeal Court judgment and in the Commission's heads of argument, they attempt to set up the wrong set of skittles to knock down. So I want to make it clear, our complaint is not that we don't understand the substance of the case made against us. In other words, we are not looking and saying we don't understand what Katz was doing, we deny that Katz did this, whatever. That is not our case. Our complaint is only that we do not understand on what date the collusion involving us is alleged to end. So, the contradictions, I think, are obvious, and I want to now just briefly have a look at what the Commission says about them, and I want to start with their heads of argument at page 42 of the heads bundle and paragraphs 1.3 and 1.4. Now, modesty, of course, prevents me from reading out 1.2. But paragraph 1.3 correctly sets out the grounds of exception. Then 1.4 says that BNP is the only respondent which takes material issue with the cessation date. Now that is a factually incorrect submission, because two others, at least two others do, and I'll give you two references. Bank of America, at paragraph 76.4 to 76.6 and 97 of their heads of argument, and Nomura at paragraphs 34.2 to 34.4 take precisely the same objection. So it is not correct to say that we are the only respondent who does that. Thereafter, can I move to paragraph 5? And here, the Commission makes, for some reason, the submission that Katz is alleged to have engaged in the full range of conduct forming part of the SOC. Of course, it's common cause that Katz was employed by BNP Paribas for a reasonable length of time. And they then set out in 5.1 to 5.7 various examples. But what of it? What complaint does this answer? This answers the complaint that we didn't make, not the complaint that we did make. And they cannot answer the complaint that we did make by referring to Katz's involvement. That's got nothing to do with the end date. I then want to go to paragraph 6, and again, we get the general allegations. Overall, Katz is directly implicated in at least 67 instances. Got nothing to do with the complaint that we've said. Doesn't answer anything, not a single thing. And then I want to go to page 48, and I want to deal briefly with this tired formulation which we see in footnote 30, where I think there's an attempt to characterize what we say as formalism and technicality. That is, of course, always what people do when faced with the implications of inaccurate pleading. And I would simply submit that requiring them to plead the end date is not formalistic, it's not technical, it's really just doing no more than to ask them to comply with CAC 1, which I'll come to in due course. And then on page 50, on paragraph 11, they say the referral sets out the Commission's case in respect of cessation of the SOC, and then they continue to say, on a proper read, is consistent and not contradictory. But I think I've demonstrated that if you have no knowledge of when the end date is, then it is impossible, it is logically impossible to plead that the end date was September 2013. So I'm utterly mystified. I've never quite seen a submission in argument that is so squarely 180 degrees wrong. Then they go on to say that the SOC is alleged to continue until at least September 2013. But in case we've forgotten, they say at the end of the paragraph, it is then also clear that the Commission doesn't know the date. So even in their own submission, they highlight their contradiction while denying that there's a contradiction. And then on page 51, there is a reliance, on page 51, footnote 44. There's a reliance on the Nell versus Welkovich case. Now that is, I think, in support of a submission that an exception had failed, an exception taking the point that the plaintiff had pleaded that at an unknown time and date, a medical practitioner had become involved in attending to the deceased. Now what that was a medical negligence suit, the patient who had died. And the issue was whether a duty of care had been acquired by the doctor treating her. And the defendant took the point, well, you never mentioned the beginning date, the date when she started. The court then found, you'll see that my learned friends rely on paragraph 29, but I would urge justices of this court to have a look at paragraph 20, where the judge hearing this application says, a formal doctor-patient relationship is not a necessity. In other words, she finds the missing fact was not necessary. That's why this exception was lost. And then briefly over the page to paragraph 16, where it is said of us that we want the referral to limit to one particular alleged end date. Yes, we do, and other cessation dates pleaded in the alternative or in an open-ended basis. As far as the alternatives go in the fifth option, we don't mind, but they're all internal in the fifth option. And then I want to move briefly to the judgment of the Competition Appeal Court. And that will be, I think, at page 224 of the record. And I want to go to paragraph 151. And I want to make the following observations. in the last sentence, concluding his reasons as to why he's dismissing the application, the Competition Appeal Court says, since the averment is that the SOC ended in 2013 and that Mr. Katz was employed until that date. No, that's not the averment. It's one of 5 averments. It's quite wrong for the CAC to say that's the averment as if that was the only one. Because obviously when you read that, it does look as if there were no alternatives. And then he says, and that Mr. Katz was employed until that date. That's also an argument advanced by the Commission. And may I just say this, that if they wish to tie our term, as it were, in the prohibited practice to Katz's employment, just plead it. Because Katz's last recorded involvement in the referral is on the 18th of October, 2012. But if you want to tie our involvement to Mr. Katz, then say so. The mere fact that it is said that you can do that means that's fine. Then, really just in the last 2 3/4 minutes, there's no real defence to this. I suppose the closest that the Commission comes to mounting a coherent and a logical defence is to say that it's not appealable. And on that, for that proposition, they rely on TWK and similar cases. The distinction there is TWK involved the dismissal of an exception that went to the true full merits of the case. In other words, something that could be argued. Our exception is final in effect, and that is why it is different from TWK. It is final, Justices, because we will have no opportunity between now and judgment in the tribunal to patch it up or to get a better order. Once we plead, it's over, and we will simply be saddled with the fact that we have to do the best we can, which won't be very well, with a completely inconsistent and illogical end of term date. So there is no, apart from this forum, there is no other court, there is no court at all that can assist us, and the tribunal certainly won't be able to assist us at all. When it comes to pleading, Justice, one is required to respond to an allegation in one of 3 ways. You admit it, you deny it, you confess and avoid. You can't plead to a referral by saying, this is vague and embarrassing, because after that, what does one do? And if one accepts that all the allegations are true, including both that they don't know the date and that there is a date, one just doesn't know what to do. So we say that the prospects of success are very high. There is nothing in the interest of justice that suggests that it shouldn't be granted. It is clearly appealable because it is final in effect, and we'll be saddled with this disability, as it were, the entire time. And I'm happy to say that I'm coming home 35 seconds in time. Thank you, Justice. If there are any questions, I'll be happy to take.
Thank you very much, Mr. Campbell. Am I correct, because you've pointed to several iterations of the complaint against your clients, but the nub of it all is it relates to the end date of the SOC?
That's all we do. That's all we do. It's our only complaint.
In the context of this case where the SOC is set to go through a particular period, and on your point, you don't know what the period is, because we've got different versions of it. Is it not so that, because the Commission's case is linked to Mr. Katz, isn't it?
Large part, but I don't find to Mr. Katz.
As a major player in this SOC, and Mr. Katz has had links with you. Is it unreasonable, or was it unreasonable for the CAC to rule that you must know what case you've got to answer when you bring in Mr. Katz's activities in this whole case, without focusing on just the end date?
Deputy Chief Justice, that's the distinction that we made. the mere fact that Katz is employed by us and he is alleged to be involved doesn't tell us anything about when our involvement in the conspiracy, because of course Katz left our employment as well. He joined us halfway through or two-thirds of the way through and left us as well. So, as I say, if they want to tie our involvement to the period in which we employed Katz, plead it. It's not difficult. And if I may add to that, the Commission has an enormous amount of information. Certainly it was clear from the first referral that they had access to the American proceedings and the American information. Since then, they've had at least one leniency applicant. They've settled with others. All of those parties that applied for leniency and settled were in a position to give them information. There's just absolutely no excuse for not settling on a date. And even if they find out later that it actually extended slightly further than the date they settled on, they can amend. And they'll be granted that amendment because they say we found this information only after we had pleaded. Of course they can do that. Anybody can amend. I can't see any excuse for not pleading a coherent end date. And I've tried to look.
Thank you, Mr. Campbell.
Mr. Campbell, still a follow up on this question. We know that from the papers, Mr. Katz was employed by BNP from 2011 to 2013.
Yeah.
And para 56 of the referral affidavit, it says this SOC took from September 07 until September 2013. What is confusing for the applicant in this matter?
The confusion is that is contradicted elsewhere in the referral. If one takes each paragraph in the referral and atomizes it and seals it, it's not confusing. But we've got to read the referral as a whole. One of the ways one decides exceptions, of course, is to look at the pleading as a whole. But in any case, even when we plead, we look at the pleading as a whole. And they contradict themselves. They cannot say in one paragraph that they don't know when it ended, and then say in another paragraph that it ended in September 13, and then say in another paragraph that they aren't even bound by that. It could be even sometime further in the future.
Why can't the applicant plead? Because the number of allegations against Katz, some in 2011, some in 2012, why can't, and at that time, we know that Katz was in the employ of the applicant. Why can't the applicant then respond to those allegations?
The applicant can respond to allegations, but the applicant can't respond to the contradictory allegations concerning the end of the SOC, because they are contradictory. So yes, there is stuff that we can do, but again, that's the distinction that I made at the beginning. Our complaint isn't that we don't understand the broad thrust of the case against us. Our complaint is that we don't know where to stop investigating and looking for documents and discovery, all of these things that flow from knowing when the end point is. We all need to know that.
I would have thought that you would stop when the role player or the main player in this left your employ.
No, but the Commission specifically says, sorry, please take this away. The Commission specifically says that it does not stop with him. They specifically plead that.
Thank you, Justice.
Thank you.
Yes, Mr. Campbell, first on the question of appealability, the usual position is that the dismissal of an exception is not appealable. And that would apply both to an exception on the basis of no cause of action and on vague and embarrassing. Now, whenever in High Court proceedings a dismissal, an exception on the basis of vague and embarrassing is dismissed, the defendant then has to plead to the particulars of claim. There won't be a chance for that to be fixed up. It's prejudice such as it is in having to plead to something which it finds vague and embarrassing is something with which it just has to live. Why is it different here? This is also the dismissal of an exception on the basis of vagueness and embarrassment. You're in exactly the same position as you would be as a High Court defendant who's lost such an exception to particulars of claim. Justice Rogers, there is certainly a practice that when people lose a vague and embarrassing, they accept that they were wrong in arguing that the pleading was vague and
I
embarrassing.
think that's a very wide assumption.
But we don't accept.
Have you ever come across an advocate who thought his argument was wrong?
Well, if I were to think about that, we might be here tomorrow morning. But the point is that more recently, the exception has become more sharp-edged. And in TWK, Unterhalter AJA was very clear in saying the reason why is finality. And if it has a final, if it doesn't have a final effect, but here it does have a final effect, and I'm not sure that anybody has ever given any proper consideration to it, certainly not in my experience.
As to the appealability of a vague and embarrassing exception?
As to the finality of it.
Well, it's final in the sense that unless a plaintiff of its own accord later amends its pleadings, you will have to plead to it.
Correct. And that takes it out of the TWK category.
Well, so perhaps you're going to tell me on my second question, which was as to why this court has jurisdiction. You say we have to answer an important question of law as to whether the dismissal of a vague and embarrassing exception is appealable. But leaving aside the Commission's concession, which you rely upon in your submissions, if the appeal court wrongly thought that you were not faced with a vague and embarrassing referral, why does that error, if it is an error, engage our jurisdiction? I know I think in your written submissions you refer to the fact that the Commission is a public body and it concerns the exercise of its powers, but I assume if Transnet issues a summons that somebody says is vague and embarrassing, the defendant can't say that's a constitutional matter because Transnet's a public body.
Let me put it on two bases. First of all, there is the right to a fair trial, and a right to a fair trial must, if it means anything, mean that you know with precision the case that you have to face. That's the first one. The second thing, of course, is a rule of law issue, which I should, in fact, have recalled and raised in response to your earlier question, and that is that the pleading dishonors the order made in CAC 2, which directed them. So the other constitutional issue raised is the extent to which bodies bound by CAC 2 can depart from it. Now, you recall this morning, my learned friend who leads for the Commission was very clear that CAC 2, apart from the Section 3(1) point, is correct. Sorry, CAC 1, Justice Rogers.
Question whether the Commission did or did not comply with CAC 1 in regard to pleading the end date of the conspiracy and of your client's participation in it is tied up with the vagueness and embarrassment point, because the Commission says, well, it did plead those dates. And you say, well, we don't fully understand it, but you had your day in court on whether it was vague and embarrassing, and the CAC found against you.
It is tied up. It is tied up, yes.
So is it a question, is the Commission's opposition to your appeal based on an argument that CAC 2 was not bound by CAC 1 in that respect, or simply that they say they did comply with it?
I understood them to say that they have complied.
Yes, and the appeal court in the second round evidently agreed.
Yes. Well,
so the case isn't about
I wouldn't go that far, to be honest. I wouldn't get to, they first of all mischaracterized the pleadings and said that passed muster. I wouldn't get quite as far as Justice Rogers as you did in that, on that.
Yes, thank you.
Campbell, can I just check with you? Just remind me, when was Mr. Katz employed by BNP? Just the years.
Starting in 2011 and ending in 2013.
So it covers the period. On any reading of this, what you say is a contradictory pleading referral,
Yes.
it's covered. So what's the problem? What case do you not know what
Problem is-
meet?
The problem is perfectly simple. They've specifically pleaded that our involvement in the SOC extended beyond September 13, beyond 2013. That's the problem.
Because they say that this is something within your exclusive knowledge. But to the limited knowledge that they have, they say that at least until 2013, Mr. Katz was involved with you, but if the conspiracy ever ceased, it may have continued after 2013 through other modes other than the chat rooms. What's wrong with that kind of pleading at an exception stage?
Justice Mayit, the fact that I have knowledge in every single case, a defendant has knowledge of certain facts that a plaintiff doesn't. That doesn't absolve the plaintiff from pleading the full case and all the material facts with some precision. That's
the full case or material facts.
That's the first point. The second point is that if we are to be tied, I've got no objection to being tied to the 2-year Katz period, but could somebody then please plead it? Then we've got no problem. That's all they have to do. It's not a difficult thing to fix up. I'm frankly staggered that we're still here.
And just the last question. I was intrigued by this in volume 9 in your exception, page 740. I was intrigued by this paragraph 2.3. This is what you say. First, you say in 2.1, these allegations are vague and embarrassing because you refer to the incoherence about the end date. Then 2.2, these allegations are contradictory, cannot all be correct. 2.3, this is the one that I would like you to explain. The period of BNP's participation in the SOC is one of the determinants of the quantum of the penalty, and it is entitled to be in a position to assess its potential liability. We're at exception. It's very early days to assess your potential quantum. What relevance does it have to the exception?
I'm sorry, Justice Mayit, I've lost you.
I'm at page 740.
Okay.
Volume 9, you plead into the basis for the exception. First, vague and embarrassing. 2, contradictory. 2.3, you say this, the period of BNP's participation in the SOC is one of the determinants of the quantum of the penalty and is entitled to be in a position to assess its potential liability. It's like a kid who steals fruit and says, listen, I'm not admitting my guilt, but just as a matter of interest, what potential penalty am I looking at? I don't understand that.
It's not. That's precisely what it's not asking or complaining about. It's saying, I would like to know the full period in respect of which I'm going to be held liable.
What's it got to do with the quantum of the penalty?
Because that is one of the determinants.
I say this tongue in cheek, you complain about the fact that they don't tell you when the SOC ended, but you're already anticipating your end, the sanction end, the penalty end, the quantum.
Justice Mayit,
Answer that. You don't answer that. Thank you, Mr. Campbell. Thank you, DCJ.
Thank you.
Thank you.
Thank you, Mr. Campbell. You hinted at the beginning this would be the. You hinted at the beginning that this was going to be the match of the day, correct? Anyway.
That was my tongue.
It's perhaps the last match of the day. You will accept that the cases tell us that we don't have to look at pleadings with the sort of granularity in looking at every possible detail. It also tells us that we're supposed to interpret them generously and not highlight any flaw or imperfection. I mean, that's generally the approach. Now, that being said, the case that's being advanced, really, and mindful of what our courts have said about the nature of cartel activity, the nature of collusion, is that here's a conspiracy, says it starts in 2007, but it continues until at least September 2013, not so.
Yes.
That's explanatory. That doesn't say it ended in 2013, but at least it continued until that point to our knowledge. But we're not saying it ended then, but we're able to say that to our knowledge, it ran for those years. And then it goes on to say, well, we can't say if it's ended or it continues, right? That's consistent with the first proposition, because they didn't say it ended in 2013.
Well, you
They said at least, if it continued, to our knowledge, it continued until at least. And those words at least are used advisedly. It doesn't say definitively it ended in 2013. It continued from that date until at least. And that's the first possible date when it could have ended. And then it may have continued under different guises and different forms. What I'm asking you is that, what is so vague and embarrassing about that? Or are we really looking for imperfections and flaws? When one looks at it in its totality, doesn't it provide a sufficient basis? And that's all.
Justice Colopin, before, or maybe after, slightly after, the paragraph that you referred to, saying to at least September 2013, the Commission pleaded that they had no knowledge of the end date. Now, if somebody can explain to me why those two comments are consistent and not contradictory, well, I'd withdraw the exception.
Okay.
They're not.
Well,
They're
let's
completely
see if we can, and maybe then I can hold you to undertaking. If someone says it continued at least until then, right? So,
but if they don't if they say that they don't know when it ended, how can they say it continued until at least?
well, what's inconsistent about that? Because if I'm aware of a conspiracy, and I have information that at least objectively shows this conspiracy ran between this period, right? Then I'm entitled to say, to my knowledge, it ran from this point at least until that point. I can't say beyond that if it continued to run. I don't know if those conspirators are still in the business. I don't know if they passed on. So there's nothing inconsistent with that. So will you withdraw the exception now?
No, certainly not, because it is inconsistent.
I thought you wouldn't.
Because
Yeah,
you can't both not know something and know it.
Okay. Thank you, Mr. Wilson.
Thank you, Mr. Campbell. That seems to be it. Mr. Ngogaitobi.
Sorry. Thank you, Deputy Chief Justice. Could I start with the question of appealability? So the first objection we take is that this is not appealable. We rely on the judgment of this court in Pretorius versus Transport Pension Fund, in particular in paragraph 21. So that's in 2019, volume 2 SA, page 37, paragraph 21. But this is all common ground. Dismissal of an exception is not appealable. Why? Because it's not dispositive. Unlike upholding an exception on the basis that the claim is bad in law, because then the claim is dismissed. Now, of course, in this court, the standard is interest of justice. So even if something is not dispositive, interest of justice may require that it be entertained. But there's nothing in the interest of justice that requires this court to entertain this appeal at all. The claim that the pleading is unclear is a baseless claim, because there are three submissions made, but the second and the third are tied to the first. And the first is this conduct continued at least. In other words, the minimum we know is September 2013. The maximum we don't know. So that's so clear, and there's nothing contradictory there, which is why the pleading thereafter says the conduct would have continued beyond the minimum period that we have to a maximum period that is never, unknown. Now, for vague and embarrassing, there is an additional requirement of prejudice. So because it's vague and embarrassing, it's not a failure to disclose an action. Are they embarrassed? The embarrassing part is embarrassed in the sense that you are prejudiced because you cannot answer. That's what the embarrassing is. So are they embarrassed by that? They're not embarrassed by that. Because if their point is, for us as BNP, it ended with the departure of cuts, they can plead that. And what we don't know is the balance beyond the at least part. And if they have no knowledge, they can say we have no knowledge. So they are not embarrassed in pleading on that score either. So there is no contradiction. This horse has been beaten so many times, but it has no legs. That's the end of it. But there is a third point here, which is when it comes to the question of the cessation, the law established by the Competition Appeal Court in the case of power construction versus the Competition Commission 2017, Volume 2, CPLR 589, based on judgments like Paramount Mills and Videx Wire Products, really says this: what is a date of cessation of the conduct? The date of cessation of the conduct is the date by which the benefits of the cartel conduct stop flowing to the beneficiaries. And it's so clear when they say paragraph 43 of the judgment, they say, the prohibited conduct does not end or cease with the conclusion of the agreement fixing the selling price. It continues to exist, and its effect continues to be felt when the future prices agreed upon pursuant thereto are implemented. So one is no longer now focused on the actual deal between the colluders, but is looking at the wider market impact. So when that market impact stops, that's when the conduct stops. And then the same approach is taken in Videx Wire Products, cited in paragraph 44 of the judgment in power construction. This is what is said in paragraph 44. It says, a prohibited practice is generally constituted by initiating conduct followed by the anti-competitive effects intended by the colluding parties. Section 67(1) envisages that a prohibited act will be one which continues over a period of time and is thus capable of ceasing. The prohibited act is thus not constituted only by the initiating conduct, but also within appropriate bounds by its intended ongoing effects. To take a simple example, if two firms collude with each other to fix prices, and if each of them then concludes a 3-year supply agreement with separate customers at the fixed prices, the prohibited price fixing is constituted by the initiating act, that's the deal with the colluder, and by the conclusion and performance of the resultant contracts with the customers. So it is a wide thing to talk about a collusion. But for our purposes, the only people who know when the benefits stop flowing are the parties to the collusion. So they are the best person to tell us when did the conduct cease. Because at this point in time, the Commission's information only knows the departure of cuts, but the departure of cuts is not in law the cessation date. And then finally, this point has been debated in full before the Competition Appeal Court. It is one of the few instances where the Competition Appeal Court is completely correct. Because what it says is that in order for you to draw us into this debate, you must show us how you are prejudiced. And then it says you cannot show us how you are prejudiced. And for that reason, I'm dismissing your appeal. So that's, in fact, a commendable approach to take. So we would therefore submit that this is a hopeless appeal. It should be dismissed. Thank you, Deputy Chief Justice.
Thank you very much, Advocate Ngoitobi. Any questions? Go on.
Take it here as well, the Commission doesn't raise any challenges to jurisdiction.
We should have, I think this case is different to every other case. We should have actually argued that it does not engage the jurisdiction of this court. But I looked at our answering affidavit, we expressly concede that it's within the jurisdiction.
Thank you, Mr. Mwakatobi.
Well, that seems to be it.
Thank you, Deputy.
Thank you, Advocate Kuzubi. Advocate Campbell.
Thank you, Deputy Chief Justice. Just two very short points. One is my learned friend addressed you on the proposition that the only people who know the full length of a cartel are the colluding parties themselves. That is so initially. But remember that they have one leniency applicant and they have 4 or 5 settlements. So in fact, 5 of those colluding parties are now in touch with them and have settled with them. So of course, the knowledge of the colluding parties is now the knowledge of the Commission, so they can't pretend that there's any distinction between the two in that respect. Finally, on the question of prejudice, it seems to me to be extremely obvious if I admit in one part of the referral that the Competition Commission has no knowledge of when the practice ended. What do I do when I get to the allegation that it ended in September 2013? I haven't got the slightest idea. But I'm going to find myself, I know, I'm quite sure of it, pleading inconsistently. There it is. Thank you, Deputy Chief Justice.
Mr. Campbell, what's the constitutional issue in this matter?
Principle of fair trial and rule of law, because the Competition Appeal Court required them to plead an end date.
That means every exception would entertain this court's jurisdiction.
Well, this one does. I haven't given, I don't know what others look like.
Yes, if that's the argument taken to its logical conclusion, then every exception would fall within this court's jurisdiction.
Well, if there is a prior court order by a competent court saying you need to plead the following elements, then you would always have a rule of law on a constitutional issue.
Yes, thank you, Mr. Campbell.
Yours is a proper exception. I suppose if we do uphold it, what must happen is what normally happens is they must fix the problem.
Fix it, yeah.
Now, you don't have to answer this. This is a rhetorical question. If everybody had raised the proper exception, excluding the other things, that's probably, we probably wouldn't be here. But anyway, thank you.
Well, I think we've come to the end of this case. We'll reserve our judgment. Thank you very much to all the counsel, your written submissions, your oral submissions. Thank you very much. Could we have the responses to the Commission's list of errors of law by Monday? No, but why Monday? Because they only had a day. So could we have it tomorrow, please? I'm sure that's fair. Thank you very much. Court adjourns.